Paper, Environmental Laws 1 Question 1, Judicial Activism and Environment Protection. Judicial activism has taken maximum care of environment protection. Discuss with the help of decided cases. Conceptual framework of judicial activism in environmental law. Judicial activism in environmental law emerged prominently in the 1980s, driven by the relaxation of locus standi and the rise of PIL. This allowed citizens and non-governmental organizations, NGOs, to approach the courts under Articles 32 and 226, seeking remedies for environmental degradation. The judiciary has adopted an activist stance by expanding the scope of fundamental rights, particularly Article 21, to encompass the right to a pollution-free environment. Incorporating international environmental principles, such as sustainable development, polluter pays, and precautionary principles. Issuing innovative directives, including the creation of monitoring committees and green benches. The judiciary's approach has been both progressive and pragmatic, addressing complex environmental challenges while balancing developmental imperatives. The following sections analyze landmark cases that exemplify this activism. Landmark cases demonstrating judicial activism. Rural litigation and entitlement. Kendra v. State of Uttar Pradesh, 1985. The Rural Litigation and Entitlement Kendra v. State of Uttar Pradesh case, also known as the Dehradun Valley litigation, is a seminal case in Indian environmental jurisprudence. The case involved limestone quarrying in the Mussoorie Hill Range, which caused significant ecological disturbance, including deforestation and soil erosion. A voluntary organization filed appeal under Article 32, alleging that mining activities violated environmental laws and endangered the local ecosystem. The Supreme Court appointed an expert committee to assess the ecological impact. Based on the committee's findings, the court ordered the closure of mining operations in ecologically sensitive areas, while allowing limited operations in less vulnerable zones. The court emphasized that the right to a healthy environment is integral to Article 21, stating that environmental protection outweighs short-term economic gains. It also introduced the concept of balancing ecological preservation with economic hardship to lessees, setting a precedent for sustainable development. This case marked the judiciary's willingness to intervene proactively, using PIL as a tool to enforce environmental laws. It also highlighted the court's reliance on expert committees to inform its decisions, a practice that became a hallmark of environmental litigation. WEB 3. 2 MC Mehta v Union of India, L.L.M gas leak case, 1986. The MC Mehta v Union of India case, popularly known as the L.L.M gas leak case, is a landmark in the evolution of environmental liability principles. The case arose from a leakage of L.L.M gas from Shriram Foods and Fertilizers in Delhi, which resulted in 1 death and multiple injuries. MC Mehta, an environmental activist, filed appeal under Article 32, seeking the closure of the hazardous industry. The Supreme Court introduced the principle of absolute liability, departing from the traditional strict liability doctrine under Rylands v. Fletcher. The court held that enterprises engaged in hazardous activities are absolutely liable for any harm caused, irrespective of reasonable care. Chief Justice P. N. Bhagwati observed, where an enterprise is engaged in a hazardous or inherently dangerous activity, the enterprise is strictly and absolutely liable to compensate all those affected by the accident. WEB 16. The court also issued directives for the relocation of hazardous industries away from populated areas and mandated stringent safety measures. This case established the judiciary's role in evolving new legal principles to address modern environmental challenges, reinforcing the right to a safe environment under Article 21 WEB 9. MC Mehta v Union of India, Gunga pollution case, 1988. In the Gunga pollution case, MC Mehta filed appeal highlighting the pollution of the Gunga River by tanneries in Kanpur. The untreated effluents discharged into the river posed severe health risks to communities dependent on it. The Supreme Court, invoking Article 32, ordered the closure of non-compliant tanneries unless they installed primary treatment plants within 6 months. Justice E.S. Venkataramaya's judgment emphasized that industries cannot operate at the expense of environmental health, drawing an analogy, just like an industry which cannot pay minimum wages to its workers cannot be allowed to exist, a tannery which cannot set up a primary treatment plant cannot be permitted to continue. WEB 20. The court also directed the central government to implement public awareness programs to promote environmental compliance. This case underscored the judiciary's role in enforcing the polluter pays principle, holding industries accountable for environmental harm. It also demonstrated the court's use of continuing mandamus, keeping the case open to monitor compliance, a procedural innovation in environmental litigation. WEB 6. Vellore Citizens Welfare Forum v Union of India, 1996. The Vellore Citizens Welfare Forum v Union of India case addressed pollution caused by tanneries in Tamil Nadu, which contaminated groundwater and agricultural land. The Supreme Court explicitly recognized the principles of sustainable development, precautionary principle, and polluter pays principle as part of Indian environmental law. The court directed the establishment of the Loss of Ecology Authority to assess damages and ensure compensation for affected communities. The judgment stated, the precautionary principle and the polluter pays principle are essential three features of sustainable development. WEB 6. The court also emphasized intergenerational equity, ensuring that natural resources are preserved for future generations. This case marked a significant step in integrating international environmental principles into domestic law, showcasing the judiciary's progressive approach. WEB 0. T. Engodev Arman Thirumal Pad v Union of India, 1995-2014. The T. Engodev Arman case is one of the longest-running environmental litigations in India, addressing deforestation and forest conservation. Initiated through appeal, the case led to the Supreme Court's establishment of the Compensatory Afforestation Funds Management and Planning Authority, CAMPA, to oversee afforestation efforts and compensate for deforestation. The court banned mining activities in protected areas like the Sariska Wildlife Sanctuary and issued directives to enforce the Forest Conservation Act, 1980. The judgment reinforced the public trust doctrine, holding that natural resources are held in trust by the state for public benefit. The court's proactive monitoring through continuing mandamus ensured sustained implementation of its orders. WEB 20. M.K. Ranjitsan v Union of India, 2024, in a recent landmark ruling, the Supreme Court in M.K. Ranjitsan v Union of India recognized the right to be free from the adverse effects of climate change as a fundamental right under Articles 14 and 21. The case concerned the protection of the great Indian bustard, an endangered species, and its habitat, threatened by overhead power lines. The court directed the installation of underground power lines and bird diverters to mitigate the impact on the species. Chief Justice D.Y. Chandrachud emphasized that climate change infringes on the right to life and equality, particularly for vulnerable communities. The judgment highlighted the absence of a comprehensive climate change law in India and urged legislative action to address this gap. WEB 11, WEB 15. Key principles established through judicial activism. The judiciary has developed several principles that form the bedrock of Indian environmental law, sustainable development, recognized in cases like Vellore Citizens and Bombay Dyeing. This principle balances economic progress with environmental protection. WEB 0. Polluter pays principle, enforced in cases like MC Mehta, Ganga pollution, and Bikri. It holds polluters liable for environmental restoration. WEB 9, WEB 17. Precautionary principle, applied in Vellore Citizens and Gene Campaign v Union of India, it mandates preventive measures against potential environmental harm. WEB 2. Absolute liability, introduced in the LL.M gas leak case, it imposes strict liability on hazardous industries without exceptions. WEB 16. 4. Public trust doctrine, upheld in MC Mehta v Kamal Nath, it asserts that natural resources are held in trust for public benefit. WEB 17. Intergenerational equity, emphasized in State of Himachal Pradesh v Ganesh Wood Products, it ensures resource preservation for future generations. WEB 22. Challenges and criticisms of judicial activism. While judicial activism has significantly advanced environmental protection, it faces several challenges: overreach and separation of powers. Critics argue that the judiciary sometimes encroaches on executive and legislative functions, as seen in cases like State of Himachal Pradesh v Yogindra Mohan Sen Gupta, where the court approved a development plan despite environmental concerns. WEB 2, WEB 21. Selective intervention. The judiciary's selective intervention, such as non-action in wetland protection cases, raises questions about consistency. WEB 21. Implementation gaps. Despite robust judgments, enforcement remains weak due to inadequate regulatory mechanisms and lack of public awareness. WEB 14. Development versus environment conflict. Balancing developmental projects with environmental protection remains a challenge, as seen in the Taj Trapezium case, where economic concerns were weighed against environmental harm. WEB 22. 5. Question 2. General powers of central government for environment protection. What are the general powers of the central government to take measures to protect and improve environment? Constitutional and legal framework. The Indian Constitution provides the foundation for environmental protection. Article 48A directs the state to protect and improve the environment and safeguard forests and wildlife. WEB 14. Article 51A G imposes a fundamental duty on citizens to protect the environment, indirectly obligating the state to facilitate this duty. WEB 14. 7th Schedule. Environment falls under the concurrent list, enabling both central and state governments to legislate, with central laws prevailing in case of conflict. WEB 9. Key environmental statutes include, Water, Prevention and Control of Pollution, Act, 1974, regulates water pollution through central and state pollution control boards. WEB 20. Air, Prevention and Control of Pollution, Act, 1981, addresses air and noise pollution. WEB 5. Environment, Protection, Act, 1986, provides a comprehensive framework for environmental protection. WEB 14. The EPA, 1986, is the cornerstone of the central government's authority, granting it broad powers to prevent, control, and abate environmental pollution. General powers of the central government under the Environment, Protection, Act, 1986. The EPA, 1986, under Section 3, empowers the central government to take all necessary measures to protect and improve the environment. These powers are detailed below, categorized for clarity. Rulemaking and standard setting. Section 3, 2. The central government can establish standards for the quality of air, water, and soil, specifying permissible pollutant levels for different areas. WEB 14. Section 6. Authorizes the formulation of rules to regulate environmental pollutants, industrial processes, and emission standards. WEB 9. Example, the Noise Pollution, Regulation and Control, Rules, 2000, set ambient noise standards for industrial, commercial, residential, and silence zones, prohibiting loudspeaker use between 10 p.m. and 6 a.m. WEB 9. 6. In MC Mehta v Union of India, Ganga pollution case, 1988, the Supreme Court directed the central government to enforce water quality standards under the EPA, ordering tanneries in Kanpur to install primary treatment plants to prevent Ganga River pollution. WEB 20. Regulation of industrial and environmental activities. Section 3, 2. The central government can restrict industrial operations or processes in environmentally sensitive areas. WEB 14. Section 5, empowers the issuance of directions to close, prohibit, or regulate industries causing environmental harm. WEB 9. Example, the Coastal Regulation Zone, CRZ, notification, 1991, issued under the EPA, restricts industrial activities in coastal areas to protect marine ecosystems. WEB 3. In MC Mehta v Union of India, Taj Trapezium case, 1996, the central government was directed to relocate industries around the Taj Mahal to reduce air pollution, showcasing its authority to regulate industrial activities. WEB 22. Environmental Impact Assessment, EIA, and Clearances Section 3, 2, B mandates environmental clearances for projects likely to cause significant environmental impact. WEB 14. EIA Notification, 2006, requires prior environmental clearance for developmental projects, ensuring sustainable development. WEB 0. In T. Engodev Arman Thirumal Padvi Union of India, 1995-2014, the Supreme Court reinforced the central government's role in conducting EIAs for forest-related projects, establishing the Compensatory Afforestation Funds Management and Planning Authority, CAMPA, WEB 20. Appointment of Authorities and Delegations. Section 3, 3 allows the central government to appoint authorities, such as the Central Pollution Control Board, CPCB, to enforce environmental laws. WEB 14. Example, the CPCB sets national standards and coordinates with state pollution control boards, SPCBs, to monitor pollution. WEB 20. In Vellore Citizens Welfare Forum v Union of India, 1996, the Supreme Court directed the central government to establish the Loss of Ecology Authority under the EPA to assess damages caused by tanneries, illustrating the use of delegated powers. WEB 0. 7. Inspection, Monitoring, and Enforcement. Section 10, authorizes officers to inspect premises, seize equipment, and collect samples to ensure compliance. WEB 14. Section 11, empowers entry and search for evidence of environmental violations. WEB 9. In MC Mehta v Union of India, LL.M gas leak case, 1986, the central government's inspection powers were critical in identifying safety violations at Shriram Foods and Fertilizers, leading to the Supreme Court's imposition of absolute liability. WEB 16. Penalties and Legal Action. Section 15, prescribes penalties for contravention, including imprisonment up to 5 years or fines up to Rs1 lakh, with additional fines for continued violations. WEB 14. Section 16, holds company heads accountable for environmental offences. WEB 9. In Indian Council for Enviro Legal Action v Union of India, Bikri case, 1996, the central government enforced penalties against chemical industries for groundwater contamination, applying the polluter pays principle. WEB 17. Coordination with states and international obligations. Section 3, 2, 12 facilitates coordination with state governments and international bodies to implement environmental treaties. WEB 14. Example, India's commitments under the Paris Agreement, 2015, are implemented through central government policies, such as the National Action Plan on Climate Change. WEB 15. In M.K. Ranjitsan v Union of India, 2024, the Supreme Court urged the central government to align domestic policies with climate change obligations, directing sustainable infrastructure solutions to protect the Great Indian Bustard. WEB 11. Judicial oversight and activism. The judiciary has played a crucial role in ensuring the central government exercises its powers effectively, often through public interest litigations, PILs. Landmark cases. MC Mehta v Union of India, LL.M gas leak case, 1986. The Supreme Court introduced the principle of absolute liability, compelling the central government to regulate hazardous industries under the EPA. WEB 16. MC Mehta v Union of India, Ganga pollution case, 1988. The court directed the central government to enforce water quality standards and monitor tannery compliance, using continuing mandamus. WEB 208. Vellore Citizens Welfare Forum v Union of India, 1996. The court incorporated sustainable development, precautionary, and polluter pays principles, directing the central government to establish authorities for environmental restoration. WEB 0. T. Engodev Arman Thirumal Padvi Union of India, 1995-2014. The court mandated the central government to regulate forest conservation, establishing CAMPA to manage afforestation funds. WEB 20. M.K. Ranjitsan v Union of India, 2024. The court recognized the right to be free from climate change effects under Article 21, directing the central government to implement sustainable infrastructure policies. WEB 11. Judicial directives. The judiciary has used innovative remedies, such as continuing mandamus, monitoring compliance over time, as in the Gunga pollution case. WEB 20. Expert committees, appointing committees to assist in technical assessments, as in the Taj Trapezium case. WEB 22. Principle integration, incorporating international principles like sustainable development and public trust doctrine. WEB 0. Critical evaluation strengths comprehensive authority. The EPA provides a flexible framework for addressing diverse environmental issues. WEB 14. Judicial support. Landmark cases ensure accountability and enforcement of central government powers. WEB 9. International alignment. The central government's powers facilitate compliance with global treaties. WEB 15. Challenges implementation gaps. Weak enforcement by CPCB and SPCBs due to resource constraints. WEB 14. Bureaucratic delays. Slow issuance of clearances and rules hampers timely action. WEB 21. Development versus environment conflict, balancing economic growth with environmental protection, as seen in the Narmada Dam case, remains challenging. WEB 22. 9. Lack of comprehensive climate law, absence of specific legislation for climate change limits proactive measures. WEB 11. 10. Question 3. Penalties and offenses under Environment Protection Act, 1986. Discuss the provisions of the Environment Protection Act, 1986 regarding the penalties and offenses by companies and government departments. Overview of the Environment Protection Act, 1986. The EPA, 1986, was enacted under Article 253 of the Constitution of India, following India's commitments at the United Nations Conference on the Human Environment, 1972. The Act is an umbrella legislation, granting the central government wide-ranging powers to regulate environmental pollution. It covers air, water, and land pollution and provides mechanisms for the prevention, control, and abatement of environmental harm. Sections 15 to 17 of the Act specifically address offenses and penalties, including those committed by companies and government departments, reflecting the legislature's intent to hold all entities accountable, irrespective of their nature. Provisions relating to offenses and penalties. Section 15 of the EPA, 1986, is the cornerstone provision dealing with penalties for contravention of the Act or rules, regulations, or directions issued thereunder. It states, whoever fails to comply with or contravenes any of the provisions of this Act, or the rules made or orders or directions issued thereunder, shall, in respect of each such failure or contravention, be punishable with imprisonment for a term which may extend to 5 years or with fine which may extend to 1 lakh rupees, or with both, and in case the failure or contravention continues, with additional fine which may extend to 5,000 rupees for every day during which such failure or contravention continues after the conviction for the first such failure or contravention. If the contravention continues beyond 1 year after the date of conviction, the offender may face imprisonment for a term that may extend to 7 years. This provision establishes a stringent penalty regime to deter non-compliance, emphasizing both punitive and deterrent measures. Offenses by companies, Section 16. Section 16 of the EPA, 1986, specifically addresses offenses committed by companies. It adopts the principle of vicarious liability, ensuring that individuals responsible for the conduct of a company's business are held accountable. The section provides, where any offense under this Act has been committed by a company, every person who, at the time the offense was committed, was directly in charge of, and was responsible to, the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. 11. However, a person is not liable if they can prove that the offense was committed without their knowledge or that they exercised all due diligence to prevent its commission. Furthermore, if the offense is attributable to any director, manager, secretary, or other officer of the company with their consent, connivance, or neglect, such individuals are also deemed guilty and liable for punishment. This provision reflects the doctrine of lifting the corporate veil, ensuring that individuals behind a corporate entity cannot escape liability for environmental violations. The emphasis on due diligence underscores the expectation that company officials proactively ensure compliance with environmental regulations. Offenses by government departments. Section 17 extends the scope of liability to government departments, a unique feature of the EPA, recognizing that public entities can also contribute to environmental degradation. The section states, where an offense under this act has been committed by any department of government, the head of the department shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Similar to Section 16, the head of the department is exempt from liability if they prove that the offense was committed without their knowledge or that they exercised due diligence to prevent it. This provision ensures that government departments, which often manage large-scale projects with significant environmental impacts, are held accountable for non-compliance. Judicial interpretation and leading case laws. The judiciary has played a pivotal role in interpreting and enforcing the provisions of the EPA, 1986, particularly through landmark cases that have shaped the understanding of corporate and departmental liability. MC Mehta v. Union of India, 1987, the LL.M gas leak case. The case of MC Mehta v. Union of India, Air 1987 SC 1086, also known as the LL.M gas leak case, is a seminal judgment that underscored the liability of companies for environmental harm. In this case, a leakage of LL.M gas from Shriram Foods and Fertilizers Industries in Delhi caused significant environmental and public health concerns. The Supreme Court, while dealing with the case under the EPA, 1986, introduced the principle of absolute liability, holding that enterprises engaged in hazardous activities are strictly liable for any harm caused, irrespective of negligence. Although the case primarily focused on tortious liability, it highlighted the application of Section 16, as the company's management was held accountable for failing to ensure safety measures. The court emphasized that companies handling hazardous substances must adopt the highest standards of care, and failure to do so would attract penalties under the EPA. The judgment reinforced the need for corporate accountability and influenced subsequent environmental jurisprudence. 12 Vellore Citizens Welfare Forum v. Union of India, 1996, in Vellore Citizens Welfare Forum v. Union of India, Air 1996 SC 2715, the Supreme Court addressed pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Polluter River, affecting water quality and public health. The tanneries, operating as companies, were found to have violated the EPA, 1986, by failing to comply with environmental standards. The court invoked Section 16 to hold the companies and their responsible officers liable for the pollution. The judgment introduced the polluter pays principle, mandating that the polluting industries bear the cost of remediation. The court directed the closure of non-compliant tanneries and imposed penalties under Section 15, emphasizing that corporate entities cannot evade liability by claiming ignorance. This case is a classic example of how Section 16 ensures that both the company and its officers face consequences for environmental violations. Indian Council for Enviro-Legal Action v. Union of India, 1996, the Bikri case. The Indian Council for Enviro-Legal Action v. Union of India, 1996, 3 SCC 212, commonly known as the Bikri case, involved severe groundwater contamination caused by chemical industries in Bikri village, Rajasthan. The industries, operating as companies, discharged untreated effluents, violating the EPA, 1986. The Supreme Court, applying Section 16, held the companies and their directors liable for the environmental damage. The court reiterated the polluter pays principle and ordered the industries to compensate for the remediation of the affected area. This case highlighted the importance of due diligence under Section 16, as the directors failed to prove that they had taken adequate measures to prevent the offense. The judgment underscored the judiciary's commitment to enforcing corporate accountability for environmental violations, ensuring that penalties under the EPA are effectively implemented. Union Carbide Corporation v. Union of India, 1989, the Bhopal gas tragedy. The Bhopal gas tragedy, adjudicated in Union Carbide Corporation v. Union of India, Air 1990 SC 273, remains one of the most significant cases influencing the EPA, 1986. The leakage of methyl isocyanate gas from Union Carbide's plant in Bhopal resulted in thousands of deaths and long-term environmental damage. Although the case was primarily settled through a compensation agreement, it highlighted the application of Section 16, as the company and its responsible officers were held accountable for failing to maintain safety standards. The tragedy led to the enactment of the EPA, 1986, and underscored the need for stringent provisions to hold companies liable for environmental disasters. The case also prompted amendments to strengthen corporate liability, ensuring that officers in charge cannot escape punishment by claiming lack of knowledge. Application to government departments. While judicial precedents specifically addressing Section 17 are less common, the provision has been invoked in cases involving government projects. For instance, in T. N. Godavar Manthiru 13 Mulpad v. Union of India, 1997, 2 SCC 267, the Supreme Court addressed illegal deforestation activities involving government departments. The court held that the head of the department responsible for forest management was liable under Section 17 for failing to ensure compliance with environmental regulations. Another example is the pollution of the Yamuna River, where government departments responsible for sewage treatment were found negligent. In cases like MC Mehta v. Union of India, 1988, Air 1988 SC 1037, the court emphasized that government entities must adhere to environmental standards, and heads of departments are accountable for violations under Section 17. Illustrative examples to further elucidate the application of Section 16 and 17, consider the following hypothetical scenarios. 1. Corporate offense: a chemical manufacturing company, XYZ Limited, discharges untreated effluents into a nearby river, violating the effluent standards prescribed under the EPA, 1986. The Pollution Control Board issues a notice, and upon investigation, it is found that the company's plant manager was aware of the non-compliance but failed to act. Under Section 16, both XYZ Limited and the plant manager are liable for penalties under Section 15, which may include imprisonment up to 5 years and a fine up to 1 lakh rupees. If the manager can prove due diligence, they may avoid liability, but the company remains accountable. 2. Government department offense: a state government's public works department, PWD, undertakes a road construction project without obtaining the required environmental clearance, leading to deforestation in a protected area. The head of the PWD is held liable under Section 17 for the offense, facing penalties under Section 15. If the head can demonstrate that the violation occurred without their knowledge and that they had implemented measures to ensure compliance, they may be exempt from liability. These examples highlight the practical application of the EPA's provisions, ensuring that both private and public entities are held accountable for environmental violations. Critical analysis: the provisions of Section 16 and 17 are robust in their intent to ensure accountability, but their implementation faces challenges. For companies, the requirement of proving due diligence under Section 16 places a significant burden on corporate officers, encouraging proactive compliance. However, the lack of clear guidelines on what constitutes due diligence can lead to inconsistent judicial interpretations. In the Vellore case, for instance, the court emphasized the need for tangible evidence of preventive measures, but smaller companies may lack the resources to implement such systems. For government departments, Section 17 is a progressive step, as it holds public entities accountable, which is rare in environmental legislation globally. However, enforcement against government departments is often weaker due to bureaucratic resistance and lack of political will. The Yamuna River pollution cases demonstrate that while courts can impose liability, practical Rem 14 dietitian often lags due to systemic inefficiencies. The judiciary's role in interpreting these provisions has been instrumental, with cases like the LL.M gas leak and Bachao reinforcing strict liability and polluter pays principles. However, the reliance on judicial intervention highlights the need for stronger administrative enforcement mechanisms to complement the EPA's penal provisions. 15. Question 4. Powers of state government for prevention and control of air pollution. What are the powers of the state government for the prevention and control of air pollution? Discuss. Legislative framework. The Air, Prevention and Control of Pollution Act, 1981. The Air Act was enacted to fulfill India's obligations under international conventions, such as the Stockholm Declaration of 1972, and to provide a structured mechanism for controlling air pollution. The Act delineates responsibilities between the central government and state governments, with the latter playing a pivotal role in enforcement at the grassroots level. State governments are endowed with specific powers under various provisions of the Air Act, which are operationalized through State Pollution Control Boards, SPCBs. Objectives of the Air Act. The primary objectives of the Air Act include prevention, control, and abatement of air pollution. Establishment of boards at the central and state levels to implement the Act. Maintenance and restoration of air quality to ensure public health and environmental sustainability. Powers of the state government under the Air Act. State governments are vested with extensive powers under the Air Act to prevent and control air pollution. These powers are exercised directly or through SPCBs, which act as the implementing agencies. Below is a detailed analysis of these powers, supported by relevant sections of the Act and examples from judicial precedents. Constitution and empowerment of state pollution control boards. Under Section 4 of the Air Act, state governments are empowered to constitute SPCBs, which are responsible for implementing the provisions of the Act within their jurisdictions. The SPCB is a statutory body comprising experts and officials appointed by the state government. Its functions include planning comprehensive programs for the prevention, control, and abatement of air pollution, Section 17. Advising the state government on matters concerning air pollution control. Conducting research and disseminating information on air pollution mitigation. 16. Example, in MC Mehta v. Union of India, 1987 Air 1086, the Supreme Court directed the Uttar Pradesh Pollution Control Board to inspect industries in Kanpur emitting air pollutants and ensure compliance with the Air Act, underscoring the pivotal role of SPCBs in enforcing state-level regulations. Declaration of Air Pollution Control Areas. Section 19 of the Air Act empowers state governments, in consultation with SPCBs, to declare any area within the state as an air pollution control area. This designation allows the imposition of specific restrictions, such as prohibiting the use of certain fuels or appliances that contribute to air pollution. The state government can also issue notifications to regulate industrial activities in these areas. Case study, in Vellore Citizens Welfare Forum v. Union of India, 1996 5 SCC 647, the Tamil Nadu government, in coordination with the Tamil Nadu Pollution Control Board, declared certain areas as air pollution control zones to regulate tannery emissions, which were causing severe air and water pollution. This case highlighted the proactive use of Section 19 to address localized pollution issues. Regulation of industrial operations. Under Section 21, no person can establish or operate an industrial plant in an air pollution control area without obtaining prior consent from the SPCB. The state government, through the SPCB, has the authority to grant or refuse consent based on environmental impact assessments. Impose conditions on industrial operations, such as the installation of pollution control equipment. Revoke consent if industries fail to comply with prescribed standards. Example, in MC Mehta v. Union of India, 1988 Air 1115, known as the Delhi pollution case, the Delhi government, through the Delhi Pollution Control Committee, enforced strict emission standards on industries and mandated the relocation of hazardous industries from residential areas to curb air pollution. Power to issue directions. Section 31A of the Air Act grants SPCBs the authority to issue directions to any person, industry, or authority to ensure compliance with the Act. These directions may include closure, prohibition, or regulation of industrial processes, stoppage or regulation of the supply of electricity, water, or other services to non-compliant entities. 17. The state government supports the SPCB by ensuring that these directions are enforced through administrative and legal mechanisms. Landmark case, in MC Mehta v. Union of India, 1997 Air 734, the Supreme Court upheld the closure of polluting industries in Agra by the Uttar Pradesh Pollution Control Board, which acted under Section 31A to protect the Taj Mahal from acid rain caused by air pollution. Power to inspect and monitor. Under Section 23, state governments, through SPCBs, can inspect industrial premises, vehicles, or any place suspected of contributing to air pollution. SPCBs are authorized to collect samples of emissions for analysis. Section 26. Enter premises to ensure compliance with pollution control norms. Direct corrective measures if violations are detected. Example: the Maharashtra Pollution Control Board regularly conducts inspections of industries in Mumbai's industrial belts, such as Thane Balapur, to monitor compliance with emission standards, as seen in cases involving chemical and textile industries. Power to restrict certain activities. Section 22A empowers the state government, through SPCBs, to approach courts for restraining activities that cause air pollution. This provision allows the state to seek judicial intervention to prohibit polluting activities in specific areas or industries. Case study, in Indian Council for Enviro-Legal Action v. Union of India, 1996 3 SCC 212, the Raj's then government sought judicial orders to restrain industries in Baikri village from emitting pollutants, showcasing the use of Section 22A to address severe environmental degradation. Power to prescribe emission standards. Under Section 17, 1, g, SPCBs, with the approval of state governments, can prescribe emission standards for industries and vehicles. These standards are tailored to local environmental conditions and are enforced through regular monitoring and inspections. Example: the Karnataka State Pollution Control Board introduced stringent emission norms for cement industries in the state, aligning with the National Ambient Air Quality Standards, NAAQS, notified under the Environment Protection Act, 1986. Power to impose penalties and initiate legal action. State governments, through SPCBs, can initiate legal proceedings against violators of the Air Act. Section 37 prescribes penalties for non-compliance, including imprisonment for up to 7 years and fines. Additionally, Section 39 allows for cognizance of offenses only upon a complaint by the SPCB or an authorized officer. 18 Landmark case, in Subhash Kumar v. State of Bihar, 1991 Air 420, the Bihar government, through its SPCB, initiated action against industries discharging pollutants into the Bachao River, which indirectly contributed to air pollution through particulate matter dispersion. The case emphasized the role of SPCBs in enforcing penal provisions. Power to delegate functions. Under Section 18, state governments can delegate certain functions to SPCBs or other authorities to ensure effective implementation of the Act. This delegation enhances administrative efficiency and allows for localized decision-making. Judicial interpretation and the role of state governments. The judiciary has played a transformative role in interpreting the powers of state governments under the Air Act, often expanding their scope through the doctrine of public trust and the principle of sustainable development. Landmark cases have reinforced the obligation of state governments to act proactively in controlling air pollution. MC Mehta v. Union of India, 1987 and subsequent cases. The series of cases filed by environmentalist MC Mehta have been instrumental in shaping air pollution control measures in India. In the 1987 case, Air 1086, the Supreme Court directed the Uttar Pradesh government to ensure that industries in Kanpur complied with emission standards. The court emphasized that state governments must exercise their powers under the Air Act to protect public health. In the Delhi pollution case, 1988 Air 1115, the Supreme Court mandated the Delhi government to relocate polluting industries and enforce vehicular emission norms, highlighting the state's responsibility to implement air quality management plans. The introduction of compressed natural gas, CNG, for public transport in Delhi was a direct outcome of these judicial interventions. Rural Litigation and Entitlement Kendra v. State of Uttar Pradesh, 1985 Air 652, this case addressed air pollution caused by limestone quarries in the Doon Valley. The Uttar Pradesh government, under court directions, closed several quarries and imposed strict environmental regulations, demonstrating the state's power to regulate industrial activities under Section 19. Challenges in implementation. Despite the extensive powers granted to state governments, several challenges hinder effective implementation: lack of coordination, inconsistent coordination between SPCBs and other state departments often delays enforcement. 19. Resource constraints. Many SPCBs lack adequate funding, technical expertise, and manpower to monitor air pollution effectively. Industrial pressure. Political and economic pressures from industries can undermine enforcement efforts. Public awareness. Limited public awareness about air pollution control measures hampers community participation. Complementary role of the Environment Protection Act, 1986. The Environment Protection Act, 1986, EPA, complements the Air Act by providing additional powers to state governments. Under Section 5 of the EPA, state governments can issue directions to close or regulate polluting industries. The EPA also empowers states to implement national ambient air quality standards and develop action plans for critically polluted areas. Example: the Gujarat government's action plan for Ahmedabad, identified as a critically polluted area by the Central Pollution Control Board, involved stricter emission norms and the promotion of cleaner technologies in industries. 20. Question 5. Powers of state boards for prevention and control of water pollution. Discuss the powers of state boards for prevention and control of water pollution under Water, Prevention and Control of Pollution, Act, 1974. Overview of the Water, Prevention and Control of Pollution, Act, 1974. The Water Act, 1974, was enacted in response to increasing industrialization and urbanization, which led to severe water pollution across India. The Act establishes a framework for regulating activities that pollute water bodies, including rivers, lakes, and groundwater. It creates a dual structure of central and state pollution control boards to ensure coordinated efforts in pollution control. While the Central Pollution Control Board, CPCB, sets national standards and coordinates activities, the state boards are primarily responsible for implementation and enforcement within their jurisdictions. The powers of state boards, outlined in various sections of the Act, encompass regulatory, monitoring, enforcement, and advisory functions, making them pivotal in achieving the Act's objectives. Powers of state boards under the Water Act, 1974. The Water Act, 1974, confers a wide range of powers on state boards to prevent and control water pollution. These powers are primarily outlined in Sections 17 to 33 of the Act and can be categorized into regulatory, monitoring, enforcement, and advisory functions. Below is a detailed analysis of these powers, supported by statutory provisions and judicial interpretations. Regulatory powers. State boards are vested with significant regulatory authority to set standards, issue consents, and regulate activities that impact water quality. Key regulatory powers include: 1. Planning and execution of programs, Section 17, 1a. State boards are empowered to plan comprehensive programs for the prevention, control, or abatement of water pollution in streams and wells within their jurisdiction. This includes identifying polluted water bodies, assessing pollution sources, and developing strategies to mitigate them. For instance, a state board may devise a program to treat industrial effluents before their discharge into a river. 2. Setting standards for sewage and trade effluents, Section 17, 1, g. State boards can prescribe standards for the discharge of sewage and trade effluents into water bodies. These standards ensure that effluents meet permissible limits for pollutants such as biochemical oxygen demand, BOD, chemical oxygen demand, COD, and heavy metals. The board may specify different standards for different industries based on their pollution potential. 3. Consent for discharge, Sections 25 and 26. Under Sections 25 and 26, no person or industry can establish or operate any industrial unit or discharge sewage or trade effluents 21 into a stream, well, or sewer without the prior consent of the state board. The board can grant consent with conditions, such as requiring the installation of effluent treatment plants, ETPs, or refuse consent if the activity is likely to cause significant pollution. For example, a textile factory seeking to discharge effluents into a river must obtain a consent to operate from the state board, which may mandate specific treatment processes. Monitoring and inspection powers. State boards are tasked with monitoring compliance and assessing water quality, which involves the following powers. 1. Inspection of premises, Section 23. State boards have the authority to enter and inspect any place, including industrial premises, to ascertain compliance with the Act. They can examine equipment, processes, and effluent discharge systems to ensure adherence to prescribed standards. For instance, a state board may inspect a chemical plant to verify that its ETP is functioning effectively. 2. Collection of samples, Section 21. State boards can collect samples of effluents or water from any stream or well for analysis. The Act specifies procedures for sample collection to ensure accuracy and admissibility in legal proceedings. The results of such analyses can be used as evidence in cases of non-compliance. 3. Survey and data collection, Section 17, 1, b. State boards are empowered to conduct surveys of water bodies to assess pollution levels and identify sources of contamination. This includes monitoring the quality of rivers, lakes, and groundwater to detect changes in pollution parameters over time. Enforcement powers. State boards have robust enforcement powers to ensure compliance and penalize violators, including 1. Issuing directions, Section 33A introduced by the 1988 Amendment. Section 33A empowers state boards to issue directions to any person, industry, or authority to prevent or control water pollution. These directions may include orders to close non-compliant units, disconnect utilities, or install pollution control equipment. Non-compliance with such directions is an offense under the Act. 2. Legal action and penalties, Sections 41 to 49. State boards can initiate legal proceedings against violators. Offenses under the Act, such as discharging effluents without consent or violating standards, are punishable with imprisonment up to 7 years and fines. For example, under Section 43, failure to comply with consent conditions can lead to imprisonment for a term ranging from 1.5 to 6 years. 3. Emergency measures, Section 32. In cases of imminent danger to public health or the environment due to water pollution, state boards can apply to a court for restraining orders 22 to prevent the discharge of pollutants. This power is critical in addressing sudden pollution incidents, such as chemical spills into rivers. Advisory and coordination powers. State boards also play an advisory role to support state governments and coordinate with other agencies. 1. Advising the state government, Section 17, 1, c. State boards advise state governments on matters concerning water pollution prevention, including the siting of industries to minimize environmental impact. For instance, a state board may recommend against locating a pesticide factory near a river to prevent contamination. 2. Coordination with other agencies, Section 17, 1, e. State boards collaborate with the CPCB and other state boards to ensure a unified approach to water pollution control. This includes sharing data, aligning standards, and coordinating interstate river pollution control programs. 3. Public awareness and research, Section 17, 1, f. and I. State boards are tasked with promoting public awareness about water pollution and conducting research to develop cost-effective pollution control technologies. They may organize workshops or publish reports to educate industries and communities. Judicial interpretation and leading case laws. The judiciary has played a crucial role in interpreting and reinforcing the powers of state boards under the Water Act, 1974, through landmark judgments that highlight their enforcement and regulatory roles. Vellore Citizens Welfare Forum v Union of India, 1996, in Vellore Citizens Welfare Forum v Union of India, Air 1996 SC 2715, the Supreme Court addressed severe water pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Polluter River. The Tamil Nadu Pollution Control Board, TNPCB, was found to have been lax in enforcing consent conditions under Sections 25 and 26. The court directed the TNPCB to exercise its powers under Section 33A to close non-compliant tanneries and ensure the installation of ETPs. The judgment introduced the polluter pays principle and precautionary principle, emphasizing the state board's duty to enforce stringent measures to protect water bodies. This case underscored the importance of state boards' regulatory and enforcement powers in combating industrial pollution. MC Mehta v Union of India, 1988, the Ganga pollution case in MC Mehta v Union of India, Air 1988 SC 1037, popularly known as the Ganga pollution case, the Supreme Court addressed the pollution of the river Ganga by industries and municipalities in Kanpur. The Uttar Pradesh Pollution Control Board, UP, was directed to exercise its 23 powers under Sections 25, 26, and 33A to regulate effluent discharges and issue closure orders for non-compliant units. The court emphasized the state board's role in monitoring and enforcing compliance, ordering regular inspections and sample analyses under Section 21. The judgment led to the establishment of the Ganga Action Plan, highlighting the state board's advisory role in shaping state-level pollution control strategies. Indian Council for Enviro-Legal Action v Union of India, 1996, the Bikri case in Indian Council for Enviro-Legal Action v Union of India, 1996, 3 SCC 212, the Supreme Court dealt with groundwater contamination caused by chemical industries in Bikri village, Rajasthan. The Rajasthan Pollution Control Board was criticized for failing to exercise its powers under Sections 23 and 33A to prevent the discharge of toxic effluents. The court directed the board to take immediate action, including closing polluting units and initiating legal proceedings under Section 43. The case reinforced the polluter pays principle and highlighted the state board's responsibility to use its enforcement powers proactively to protect water resources. Illustrative examples to illustrate the application of state board's powers: consider the following hypothetical scenarios. 1. Industrial noncompliance. A sugar factory in Maharashtra discharges untreated effluents into a nearby river, violating the standards set by the Maharashtra Pollution Control Board, MPCB, under Section 17, 1, g. The MPCB exercises its powers under Section 23 to inspect the factory, collects effluent samples under Section 21, and confirms non-compliance. Under Section 33A, the board issues a closure order until the factory installs an ETP. If the factory fails to comply, the MPCB can initiate legal action under Section 43, seeking imprisonment and fines. 2. Emergency pollution incident. A chemical spill from a factory in Gujarat contaminates a local stream, posing an immediate threat to public health. The Gujarat Pollution Control Board, GPCB, invokes Section 32 to seek a court order restraining the factory from further discharges. Simultaneously, the GPCB uses its powers under Section 33A to direct the factory to clean up the spill and install pollution control measures, demonstrating its emergency response capabilities. These examples highlight the practical application of state boards' powers in addressing both routine and emergent water pollution issues. Critical analysis. The powers conferred on state boards under the Water Act, 1974, are comprehensive, enabling them to regulate, monitor, and enforce compliance effectively. The ability to issue consents, conduct inspections, and impose penalties ensures that state boards can address water pollution at the grassroots level. Judicial interventions, as seen in cases like Vellore Citizens Welfare Forum and MC Mehta v Union of India, have strengthened these powers by holding state boards accountable for lapses and reinforcing principles like polluter pays. However, state boards face significant challenges in exercising their powers. These include 24 resource constraints. Many state boards lack adequate funding, staff, and technical expertise to conduct regular inspections and monitor water quality effectively. Industrial and political pressures. Boards often face resistance from powerful industrial lobbies and political interference, which can hinder enforcement actions. Coordination issues. Lack of effective coordination between state boards and the CPCB can lead to inconsistent standards and enforcement across states. Limited public participation. While state boards are tasked with promoting awareness, public involvement in pollution control remains limited, reducing the effectiveness of advisory efforts. The judiciary's proactive role has mitigated some of these challenges by directing state boards to act decisively, as seen in the Gunga pollution case. However, long-term effectiveness requires capacity building, greater autonomy for state boards, and enhanced public engagement. 25 Question 6, Noise Pollution and its Control by Rajasthan Noise Control Act, 1963. What do you understand by noise pollution? How is noise pollution controlled by the Rajasthan Noise Control Act, 1963? Explain. Understanding noise pollution definition and characteristics. Noise pollution is defined as unwanted sound that disrupts the activity or balance of human or animal life. WEB 14. According to the Central Pollution Control Board, CPCB, noise is any sound that causes pain or annoyance, distinguishing it from music, which pleases the listener. WEB 20. The Air, Prevention and Control of Pollution, Act, 1981, includes noise within the definition of air pollutant under Section 2A, recognizing its potential to harm human health, living creatures, plants, or property. WEB 4. Noise is measured in decibels, dB, with a threshold of hearing at 0 dB. For context, whisper, 20-25 dB normal conversation, 60 dB traffic noise, 80 dB jet engine, 120 dB noise levels exceeding 90 dB for prolonged periods can cause hearing loss, while a single exposure to 150 dB may result in permanent ear damage. WEB 5. Sources of noise pollution. Noise pollution originates from various sources, including transportation, vehicular horns, aircraft, and railway operations. WEB 4. Industrial activities, heavy machinery, mining, and construction equipment. WEB 5. Social events, loudspeakers at religious ceremonies, weddings, and public gatherings. WEB 4. Household activities, loud music, barking dogs, and kitchen appliances. WEB 4. Environmental sources, dripping taps, ticking clocks, and natural phenomena amplified by human activities. WEB 5. Effects of noise pollution. Noise pollution has multifaceted impacts: health effects, stress, high blood pressure, sleep disruption, hearing loss, and reduced productivity. WEB 6. 26 Psychological effects, lack of concentration, irritability, and mental health issues. WEB 4. Ecological effects, disruption of animal communication, reduced crop quality, and altered ecosystems. WEB 4. Social effects, annoyance, public nuisance, and interference with communication. WEB 17. Legal framework for noise pollution control in India. The control of noise pollution in India is governed by a combination of central and state legislation, supplemented by judicial activism. Central legislation. Environment Protection Act, 1986, Section 2, c, defines environmental pollution to include noise, empowering the central government to set standards. WEB 14. Air, Prevention and Control of Pollution, Act, 1981, amended in 1987 to include noise as an air pollutant, enabling state pollution control boards to regulate noise. WEB 5. Noise Pollution, Regulation and Control, Rules, 2000, establishes ambient noise standards for industrial, commercial, residential, and silence zones, prohibiting loudspeaker use between 10 p.m. and 6 a.m. except in emergencies. WEB 9. State legislation states like Rajasthan, Bihar, and Uttar Pradesh have enacted specific laws to address noise pollution. The Rajasthan Noises Control Act, 1963, is a notable example, focusing on controlling nocturnal noises in designated areas. WEB 24. Judicial role. The Indian judiciary has played a pivotal role in noise pollution control through public interest litigations, PILs. In Forum, Prevention of Environment and Sound Pollution v. Union of India, 2005, the Supreme Court held that noise pollution violates the right to life under Article 21, directing strict enforcement of noise standards and restrictions on loudspeaker use. WEB 7. Similarly, in Church of God in India v. KKR Majestic Colony Welfare Association, 2000, the court ruled that religious activities cannot justify noise pollution, emphasizing the public's right to a peaceful environment. WEB 7. The Rajasthan Noises Control Act, 1963. The Rajasthan Noises Control Act, 1963, Rajasthan Act No. 12 of 1963, is a state-specific statute designed to regulate noise in urban areas, particularly nocturnal noises that disturb public peace. Enacted on April 29, 1963, the Act extends to the entire state but applies selectively to areas notified by the state government. WEB 2. 27 key provisions. The Act comprises 10 sections, with sections 3 to 8 and 10 being the operative provisions enforced in notified areas. Below is a detailed analysis of its key provisions. Section 1, Short Title, Extent, and Commencement. The Act is titled the Rajasthan Noises Control Act, 1963, and extends to the whole of Rajasthan. Sections 1, 2, and 9 came into force immediately, while other provisions apply to areas and dates notified by the state government. WEB 2. Notifications issued between 1964 and 1973 extended the Act to municipal limits of towns like Jaipur, Jodhpur, Ajmer, and others. WEB 2. Section 2, Definitions defines noise as any sound declared to be a nocturnal noise under Section 3. Nocturnal noise refers to sounds prohibited during night hours, typically 10 p.m. to 6 a.m., in notified areas. WEB 8. Section 3, Declaration of nocturnal noise empowers the state government to declare certain noises as nocturnal by notification, proclaimed by a beat of drum or loudspeaker and affixed in public places. WEB 8. This provision targets noises like loudspeakers, musical instruments, or public performances during night hours. Section 4, Prohibition of nocturnal noise prohibits the making or continuance of declared nocturnal noises in notified areas without written permission from the prescribed authority. Exceptions may be granted for religious or cultural events, subject to conditions. WEB 8. Section 5, Abatement of noise authorizes police officers, not below the rank of sub-inspector, to direct the cessation of prohibited noises. Non-compliance may lead to seizure of equipment causing the noise. WEB 2. Section 6, Permission for certain acts allows the state government to permit specific noises, e.g., loudspeakers during festivals, for limited durations, aligning with the noise pollution rules, 2000 WEB 10. Section 7, Penalties. Contravention of the Act is a cognizable offense, punishable with a fine up to Rs 250 for the first offense and Rs 500 for subsequent offenses. WEB 7. 28 Rajasthan is unique in treating noise violations as cognizable, enabling proactive police action. WEB 7. Section 8, Powers of Magistrates empowers executive magistrates to issue orders under Section 133 of the Code of Criminal Procedure, 1973, to abate public nuisances caused by noise. WEB 18. Section 9, Rulemaking power authorizes the state government to frame rules, resulting in the Rajas then Noises Control Rules, 1964, which detail procedures for notifications and enforcement. WEB 16. Section 10, Savings ensures that actions under other laws, e.g., Indian Penal Code, are not barred by the Act. WEB 2. Rajas then Noises Control Rules, 1964. The Rajas then Noises Control Rules, 1964, supplement the Act by prescribing procedural details. Rule 3, specifies the manner of giving notice under Section 3, requiring public proclamation and affixation of notices. WEB 16. Rule 4, details the process for granting permissions under Section 4, ensuring compliance with noise limits. Judicial precedents and noise pollution. The judiciary has significantly influenced noise pollution control, complementing statutory provisions like the Rajas then Noises Control Act, 1963. Forum, Prevention of Environment and Sound Pollution v. Union of India, 2005, in this landmark case, the Supreme Court addressed noise pollution from firecrackers and loudspeakers. Chief Justice R.C. Lahoti held that excessive noise infringes the right to life under Article 21, directing noise levels not to exceed 10 dB above ambient standards or 75 dB, whichever is lower. Ban on amplifiers between 10 p.m. and 6 a.m., except in emergencies. Confiscation of equipment violating noise limits. WEB 7. This judgment reinforced the Rajas then Act's provisions by emphasizing strict enforcement in silence zones. 29. Himmat Singh v. Bhagwan Ram, 1988, in this Rajas then High Court case, the court upheld a conviction under the Rajas then Noises Control Act, 1963, for operating a loudspeaker without permission during night hours. The judgment affirmed the Act's efficacy in addressing public complaints and deterring violations. WEB 3. Church of God in India v. KKR Majestic Colony Welfare Association, 2000, the Supreme Court ruled that religious activities, such as loud prayers, cannot override the public's right to a peaceful environment. This case supports the Rajas then Act's restrictions on nocturnal noises, particularly in residential areas. WEB 7. Critical evaluation of the Rajas then Noises Control Act, 1963 strengths pioneering legislation, enacted in 1963, the Act predates central noise pollution laws, demonstrating Rajasthan's early commitment to environmental protection. WEB 24. Cognizable offences, unlike other states, violations are cognizable, enabling swift police action. WEB 7. Localized approach, the Act's applicability to notified areas allows targeted enforcement in urban centers. WEB 22. Judicial support, cases like Himmat Singh validate the Act's enforcement mechanisms. WEB 3. Limitations. Outdated penalties, fines of Rs 250-500 are inadequate to deter violations in 2025, compared to CPCB's proposed fines of Rs 1,000,1,00,000. WEB 11. Limited scope, the Act focuses on nocturnal noises, neglecting daytime pollution from construction or traffic. WEB 5. Implementation gaps, limited awareness and enforcement resources hinder effective implementation. WEB 18. Lack of ambient standards, unlike the noise pollution rules, 2000, the Act does not specify decibel limits, reducing precision in enforcement. WEB 9. Comparative analysis compared to other state laws, such as the Bihar Control of the Use and Play of Loudspeakers Act, 1955, the Rajas then Act is more proactive due to its cognizable provisions. However, it lags behind modern frameworks like the Noise Pollution Rules, 2000, which provide comprehensive ambient standards and silence zones. WEB 14. 30. Question 7, Short notes on environmental concepts. Write short notes on any two of the following. I. Doctrine of public trust. 2. Sustainable development. 3. Various causes of environmental pollution. Doctrine of public trust. Conceptual framework. The doctrine of public trust originates from Roman law, residential communis, and was later developed in common law jurisdictions, notably through the U.S. case Illinois Central Railroad v. Illinois, 1892. It posits that certain natural resources such as air, water, forests, and coastlines are held by the state as a trustee for the benefit of the public, both present and future generations. WEB 17. The doctrine imposes three key obligations on the state: resources must be preserved for public use. The state cannot alienate these resources to private entities in a manner that undermines public access or benefit. The state must act as a fiduciary, ensuring equitable and sustainable use. WEB 9. In India, the doctrine is anchored in Article 48A, Directive Principle to Protect the Environment, and Article 51A, G, Fundamental Duty to Protect Natural Resources, of the Constitution, reinforced by the judiciary's expansive interpretation of Article 21, Right to Life. WEB 14. Judicial recognition in India. The doctrine of public trust was formally introduced in Indian jurisprudence through the landmark case MC Mehta v Kamal Nath, 1997. The case involved the diversion of the Beas River by a private company, Span Motels, for constructing a resort, allegedly with the connivance of state authorities. The Supreme Court, invoking the public trust doctrine, held that the state, as a trustee of natural resources, cannot permit private interests to degrade public resources. Justice Kuldip Singh observed, the public trust doctrine primarily rests on the principle that certain resources like air, sea, waters, and forests have such great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. WEB 17. The court imposed the polluter pays principle, directing the company to restore the riverbed and pay compensation for environmental damage. This case established the doctrine as a cornerstone of environmental law, emphasizing the state's fiduciary duty to protect natural resources. WEB 9. 31. Application in other cases. T. N. Godavarman Thirumalpat v. Union of India, 1995-2014. The Supreme Court applied the public trust doctrine to regulate deforestation, banning mining in protected areas like the Saraska Wildlife Sanctuary. The court established the Compensatory Afforestation Funds Management and Planning Authority, CAMPA, to ensure sustainable forest management, reinforcing the state's role as a trustee. WEB 20. Intellectuals Forum, Tirupati v. State of Andhra Pradesh, 2006. The court invalidated the alienation of tank beds for private development, citing the public trust doctrine. It emphasized that water bodies are community resources held in trust for public use, directing their restoration. WEB 0. Fomento Resorts and Hotels Limited v. Mingwell Martins, 2009. The Supreme Court restricted construction in coastal regulation zones, invoking the public trust doctrine to protect beaches and marine ecosystems for public benefit. WEB 3. Significance and challenges. The public trust doctrine has empowered the judiciary to prevent privatization of ecologically sensitive areas, ensure intergenerational equity by preserving resources for future generations, enforce accountability on state authorities for environmental mismanagement. WEB 14. However, challenges persist, implementation gaps, weak enforcement mechanisms hinder the doctrine's practical application, as seen in cases of illegal mining. WEB 21. Development pressures. Balancing economic development with public trust obligations remains contentious, as in the Narmada Bachao Andolan v Union of India case, where dam construction was upheld despite ecological concerns. WEB 22. Limited scope. The doctrine primarily applies to traditional resources, e.g., water, forests, with limited application to emerging issues like air pollution. WEB 17. Contemporary relevance. Recent judicial pronouncements, such as M.K. Ranjitsan v Union of India, 2024, extend the doctrine to climate change, recognizing the state's duty to protect ecosystems like the Great Indian Bustard's habitat. The court emphasized that climate change mitigation is part of the public trust obligation, reinforcing the doctrine's adaptability to modern environmental challenges. WEB 11. 32. Sustainable Development Conceptual Framework. Sustainable development, defined by the 1987 Brundtland Report as development that meets the needs of the present without compromising the ability of future generations to meet their own needs, integrates economic growth, environmental protection, and social equity. WEB 0. It encompasses three core principles: intergenerational equity, preserving resources for future generations; intragenerational equity, ensuring equitable access to resources within the present generation; environmental protection, minimizing ecological harm through sustainable practices. WEB 9. In India, sustainable development is constitutionally supported by Articles 48A and 51A, g, with the judiciary incorporating international principles like the precautionary principle and polluter pays principle to operationalize it. WEB 14. Judicial recognition in India. The landmark case Vellore Citizens Welfare Forum v Union of India, 1996, marked the formal adoption of sustainable development in Indian environmental law. The case addressed pollution from tanneries in Tamil Nadu, which contaminated groundwater and agricultural land. The Supreme Court explicitly recognized sustainable development as a guiding principle, stating, "The traditional concept that development and ecology are opposed to each other is no longer acceptable. Sustainable development is the answer." WEB 0. The court integrated the precautionary principle and polluter pays principle as essential components of sustainable development, directing the establishment of the loss of ecology authority to assess damages and ensure compensation. This judgment established sustainable development as a justiciable principle in Indian law. WEB 6. Application in other cases. Rural litigation and entitlement. Kendra v. State of Uttar Pradesh, 1985. Known as the Dehradun Valley litigation, this case balanced ecological preservation with economic interests. The Supreme Court ordered the closure of limestone quarries in ecologically sensitive areas while allowing limited operations elsewhere, embodying sustainable development. WEB 3. Narmada Bachao Andolan v Union of India, 2000. The court upheld the Sardar Sarovar Dam project, emphasizing sustainable development by ensuring rehabilitation measures for displaced communities and environmental mitigation plans. WEB 22. Bombay Dyeing Manufacturing Co. Limited v Bombay Environmental Action Group, 2006. The court permitted the redevelopment of mill lands in Mumbai, subject to environmental safeguards, illustrating the balance between urban development and ecological concerns. WEB 033. M.K. Ranjitsan v Union of India, 2024. The court recognized the right to be free from climate change effects under Article 21, directing sustainable infrastructure solutions, e.g., underground power lines, to protect the Great Indian Bustard. WEB 11. Significance and challenges. Sustainable development has guided judicial decisions to balance development with environmental protection, promoted the integration of international principles into domestic law, encouraged long-term environmental planning through compensatory mechanisms. WEB 9. Challenges include implementation inconsistencies. Projects like the Tehri Dam highlight difficulties in ensuring compliance with sustainable development goals. WEB 21. Economic pressures. Rapid industrialization often prioritizes economic growth over environmental concerns, as seen in mining cases. WEB 20. Lack of comprehensive legislation. India lacks a unified sustainable development law, relying on judicial pronouncements. WEB 11. Contemporary relevance. The principle remains critical in addressing climate change, urbanization, and resource depletion. Recent cases like M.K. Ranjitsan underscore its role in promoting climate-resilient infrastructure and protecting biodiversity, aligning with global frameworks like the Paris Agreement. WEB 15. Comparative analysis. The doctrine of public trust and sustainable development are complementary principles. Scope. Public trust focuses on the state's fiduciary duty to protect specific resources, while sustainable development addresses broader socio-economic environmental balance. WEB 17. Public trust restricts privatization, e.g., MC Mehta v Kamal Nath, while sustainable development guides development projects, e.g., Narmada Bachao Andolan. WEB 22. Role. both rely on judicial activism to enforce constitutional mandates, with public trust emphasizing state accountability and sustainable development promoting balanced governance. WEB 1434 Critical evaluation. Both principles have transformed Indian environmental law. Strengths: they provide a robust framework for protecting public resources and ensuring long-term ecological sustainability, supported by landmark cases. WEB 9. Limitations: weak enforcement, judicial overreach, and lack of legislative codification hinder their efficacy. WEB 21. Future directions: integrating these principles into a comprehensive environmental law and enhancing regulatory mechanisms are essential. WEB 1135 Question 8, Powers to take samples and procedure of analysis. Report Underwater, Prevention and Control of Pollution, Act 1974. Explain the following. Under the Water, Prevention and Control of Pollution, Act 1974, I. Power to take samples. 2. Procedure of Analysis. Report. Legal framework of the Water Act, 1974. The Water Act, 1974, was enacted under Article 252 of the Indian Constitution, following resolutions by state legislatures, to provide a unified framework for preventing and controlling water pollution. Its objectives include restoring and maintaining the wholesomeness of water bodies. WEB 14. Establishing central and state pollution control boards, CPCB and SPCBs, to enforce pollution standards. WEB 20. Regulating discharges into water bodies and ensuring compliance through monitoring and penalties. WEB 9. The Act defines pollution under Section 2, E, as contamination of water or alteration of its physical, chemical, or biological properties, rendering it harmful to public health or the environment. WEB 14. The powers to take samples and the procedures for analysis reports are critical enforcement tools, ensuring that violations are substantiated with scientific evidence. Power to take samples under Section 21. Legal provisions. Section 21 of the Water Act empowers authorized officers of the CPCB or SPCBs to collect samples of water, sewage, or trade effluent for analysis to determine compliance with pollution standards. The key provisions are, Section 21, 1. An authorized officer may take samples from any stream, well, or effluent discharged from industrial or other establishments. WEB 14. Procedure for sampling: the officer must serve a notice in the prescribed form, Form 7 under the Water Rules, 1975, to the occupier or their agent, indicating the intent to take samples. WEB 8. The sample must be collected in the presence of the occupier or their agent, ensuring transparency. WEB 14. The sample is divided into two parts, one for analysis by the board's laboratory and the other sealed and handed over to the occupier for independent testing, if desired. WEB 9. 36 Section 21, 2. If the occupier is absent, the officer may proceed with sampling, provided the notice is sent by registered post and the sample is collected in the presence of a witness. WEB 14. Section 21. 3. The sample must be preserved and transported to the designated laboratory as per the Water Rules, 1975, to maintain its integrity. WEB 8. Purpose and scope: the power to take samples serves multiple purposes: evidence collection, provides scientific evidence to prove violations of discharge standards. WEB 20. Compliance monitoring, ensures industries and establishments adhere to prescribed limits for pollutants. WEB 9. Deterrence, acts as a deterrent by enabling prosecution based on credible evidence. WEB 14. The scope extends to all water bodies, including rivers, lakes, wells, and groundwater, as well as effluents from industries, sewage treatment plants, and other sources. WEB 14. Judicial application in MC Mehta v Union of India, Ganga pollution case, 1988, the Supreme Court relied on samples collected under Section 21 to ascertain the pollution levels in the Ganga River caused by tanneries in Kanpur. The court noted that the CPCB's sampling revealed high levels of untreated effluents, leading to orders for the closure of non-compliant tanneries unless they installed primary treatment plants WEB 20. This case underscored the importance of Section 21 in providing admissible evidence for judicial interventions. In Indian Council for Enviro-Legal Action v. Union of India, Bikri case, 1996, samples collected from wells and groundwater sources in Bikri village confirmed chemical contamination by industrial effluents. The Supreme Court used this evidence to enforce the polluter pays principle, directing the central government to recover remediation costs from the polluting industries WEB 17. Challenges procedural noncompliance, failure to follow prescribed sampling procedures, e.g., serving notice, or involving the occupier, can render evidence inadmissible WEB 9. Resource constraints, limited laboratory facilities and trained personnel hinder effective sampling WEB 14. Industrial resistance, occupiers may obstruct sampling, as seen in cases like Delhi Bottling Co. Private Limited v. Central Board, 1986, where procedural lapses led to disputes WEB 3. 37 Procedure for analysis reports. Under Sections 22 and 23 legal provisions, the procedure for analyzing samples and preparing reports is governed by Sections 22 and 23, ensuring scientific accuracy and legal admissibility. Section 22, Analysis of samples. Samples must be analyzed in a laboratory recognized by the central or state government under Section 17, 2, WEB 14. The laboratory prepares a report in the prescribed form, Form 8 under the Water Rules, 1975, signed by the government analyst WEB 8. The report must detail the physical, chemical, and biological parameters of the sample, comparing them against standards prescribed under Section 17 WEB 9. Section 23, Admissibility of reports. The analysis report, signed by the government analyst, is admissible as evidence in legal proceedings without further proof of the analyst's signature WEB 14. The report is conclusive evidence of the facts stated therein, subject to rebuttal by the occupier through independent testing of their sample portion WEB 9. Procedural requirements. The Water, Prevention and Control of Pollution, Rules, 1975, outline detailed procedures. Sample preservation. Samples must be preserved using appropriate methods, e.g., refrigeration or chemical preservatives, to prevent degradation WEB 8. Chain of custody. A record of sample collection, transportation, and analysis must be maintained to ensure integrity WEB 14. Timeliness. Analysis must be conducted promptly, and reports submitted within a reasonable period to avoid disputes over sample degradation WEB 9. Notification. The occupier is informed of the analysis results, allowing them to challenge the findings through their retained sample WEB 8. Judicial application. In Vellore Citizens Welfare Forum v. Union of India, 1996, the Supreme Court relied on analysis reports from CPCB laboratories to confirm groundwater contamination by tanneries in Tamil Nadu. The reports, prepared under Section 22, provided evidence of high pollutant levels, leading to the establishment of the Loss of Ecology Authority to assess damages WEB 0. The court emphasized the admissibility of these reports under Section 23, reinforcing their legal weight. 38 In MC Mehta v. Union of India, Taj Trapezium case, 1996, water sample analysis reports were used to assess the impact of industrial effluents on the Yamuna River, contributing to the court's directive to relocate polluting industries WEB 22. The standardized procedure ensured the report's credibility in court. Challenges. Laboratory limitations. Inadequate infrastructure in some SPCBs affects the accuracy and timeliness of analysis WEB 14. Disputes over reports. Occupiers may challenge the validity of reports, citing improper preservation or analysis, as seen in UP Pollution Control Board v. Mohan Meekins Limited, 2000, WEB 3. Lack of transparency. Failure to share analysis results promptly with occupiers can undermine procedural fairness WEB 9. Judicial oversight and activism. The judiciary has played a pivotal role in ensuring the effective exercise of sampling and analysis powers, often through public interest litigations, PILs. Landmark cases: MC Mehta v. Union of India, Ganga pollution case, 1988. The court used sampling evidence to enforce compliance with effluent standards, directing the central government to monitor tanneries. WEB 20. Indian Council for Enviro-Legal Action v. Union of India, Bikri case, 1996. Analysis reports confirmed chemical pollution, leading to the application of the polluter pays principle. WEB 17. Vellore Citizens Welfare Forum v. Union of India, 1996. The court relied on laboratory reports to integrate sustainable development and precautionary principles, directing remedial measures. WEB 0. M.K. Ranjitsan v. Union of India, 2024. While primarily a climate change case, the court emphasized the importance of scientific evidence, including water quality analysis, to protect ecosystems. WEB 11. Judicial directives. The judiciary has mandated strict adherence to sampling and analysis procedures to ensure fairness. WEB 9. 39. Directed the establishment of monitoring committees to oversee compliance, as in the Ganga pollution case. WEB 20. Reinforced the admissibility of analysis reports under Section 23, enhancing their evidentiary value. WEB 14. Critical evaluation strength. Scientific evidence, Sections 21-23 ensure robust evidence collection, critical for prosecuting violations. WEB 9. Procedural fairness. The requirement to involve occupiers and provide sample portions promotes transparency. WEB 14. Judicial support. Landmark cases validate the legal weight of sampling and analysis procedures. WEB 20. Challenges. Resource constraints, limited laboratory facilities and trained personnel hinder effective implementation. WEB 14. Procedural lapses. Non-compliance with notice or preservation requirements can lead to evidentiary disputes. WEB 9. Industrial non-cooperation. Resistance from polluters complicates sampling, as seen in Delhi Bottling Co. WEB 3. Outdated standards. Some effluent standards under the Water Act are outdated, reducing the effectiveness of analysis. WEB 21. 40. Question 9. Specific provisions of Indian Constitution related to environment protection. Discuss the specific provisions of the Indian Constitution which are related to protection of environment. Constitutional framework for environmental protection. The Indian Constitution integrates environmental protection through a combination of enforceable rights, guiding principles, and citizen obligations. The following sections examine the specific provisions and their implications. Fundamental rights. Part 3. Part 3 of the Constitution guarantees fundamental rights, which have been expansively interpreted by the judiciary to include environmental protection. Article 21, Right to life and personal liberty. Article 21 states, no person shall be deprived of his life or personal liberty except according to procedure established by law. The Supreme Court has interpreted this provision to encompass the right to a clean and healthy environment as an integral component of the right to life. Judicial interpretation. In MC Mehta v. Union of India, 1987 Air 1086, the Supreme Court held that pollution affecting the Ganga River violated the right to life under Article 21, as it endangered public health. The court directed industries in Kanpur to install pollution control devices or face closure, establishing that environmental degradation constitutes a violation of fundamental rights. Case study. In Subhash Kumar v. State of Bihar, 1991 Air 420, the court ruled that the right to pollution-free water and air is part of Article 21. The petitioner alleged that industrial pollution in Bachao was contaminating water sources, prompting the court to emphasize the state's obligation to protect environmental resources. Article 14, Right to equality. Article 14 guarantees equality before the law and equal protection of the laws. It has been invoked in environmental cases to challenge arbitrary state actions that permit pollution or environmental harm. Example, in Indian Council for Enviro-Legal Action v. Union of India, 1996 3 SCC 212, the Supreme Court addressed pollution caused by chemical industries in Bikri, Rajasthan. The court held that the state's failure to regulate polluting industries violated Article 14, as it discriminated against residents by exposing them to environmental hazards. 41 Article 19, 1, G. Freedom to practice profession or trade. Article 19, 1, G. guarantees the right to practice any profession or carry on any trade or business, subject to reasonable restrictions under Article 19, 6. Environmental regulations often impose restrictions on industrial activities to protect the environment. Case study, in M.C. Mehta v. Union of India, 1988 Air 1115, known as the Delhi pollution case, the Supreme Court upheld restrictions on polluting industries in Delhi, mandating their relocation to protect air quality. The court balanced the right under Article 19, 1, G, with the public interest in environmental protection. Directive Principles of State Policy, Part 4. Part 4 contains non-justiciable directive principles that guide state policy. Two provisions explicitly address environmental protection. Article 48A, Protection and Improvement of Environment, introduced by the 42nd Amendment in 1976, Article 48A mandates, the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. This provision reflects India's commitment to international environmental obligations, such as the Stockholm Declaration of 1972. Judicial application, in Sachidanand Pandey v. State of West Bengal, 1987 Air 1109, the Supreme Court relied on Article 48A to scrutinize the state's decision to lease forest land for a hotel near a zoo. The court emphasized that state actions must align with environmental protection objectives. Example, the Tamil Nadu government's efforts to conserve the Nilgiri Biosphere Reserve, including afforestation and wildlife protection programs, align with Article 48A's directive to safeguard forests and wildlife. Article 47, Duty to improve public health. Article 47 directs the state to improve public health and nutrition levels. Since environmental pollution directly impacts health, this provision indirectly supports environmental protection measures. Case study, in Rural Litigation and Entitlement Kendra v. State of Uttar Pradesh, 1985 Air 652, the Supreme Court addressed air and water pollution caused by limestone quarries in the Doon Valley. The court ordered the closure of polluting quarries, citing the state's duty under Article 47 to protect public health. Fundamental Duties, Part EVA, introduced by the 42nd Amendment in 1976, imposes duties on citizens to promote environmental conservation. 42 Article 51A, G. Duty to protect the environment. Article 51A, G, enjoins every citizen to protect and improve the natural environment including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. This provision fosters a culture of environmental responsibility among citizens. Judicial reinforcement, in M.C. Mehta v. Union of India, 1997 Air 734, known as the Taj Mahal case, the Supreme Court invoked Article 51A, G, to emphasize the collective responsibility of citizens and the state to protect the Taj Mahal from air pollution caused by nearby industries. The court directed the Uttar Pradesh government to implement measures to reduce emissions. Example, public interest litigations, PILs, filed by citizens and NGOs, such as those by the Vellore Citizens Welfare Forum, reflect the exercise of Article 51A, G.'s duty to protect the environment. Other relevant provisions. Additional constitutional provisions indirectly support environmental protection. Article 246 and the 7th Schedule. Article 246 delineates legislative powers between the Union and states through the 7th Schedule. Environmental matters are distributed across the Union list, e.g., atomic energy, state list, e.g., public health, agriculture, and concurrent list, e.g., forests, wildlife protection. The Air, Prevention and Control of Pollution, Act, 1981, and the Environment, Protection, Act, 1986, were enacted under Entry 97 of the Union List, read with Article 253, which empowers Parliament to legislate for implementing international treaties. Example, the Tamil Nadu government's regulation of tanneries under the Water, Prevention and Control of Pollution, Act, 1974, aligns with its powers under the concurrent list, Entry 17. Example 253, Legislation for International Obligations. Article 253 empowers Parliament to legislate for implementing international treaties. This provision facilitated the enactment of environmental laws following global commitments, such as the Stockholm Declaration, 1972, and the Rio Declaration, 1992. Case study, in Vellore Citizens Welfare Forum v Union of India, 1996 5 SCC 647, the Supreme Court upheld the validity of environmental laws enacted under Article 253, emphasizing the incorporation of principles like the precautionary principle and the polluter pays principle into Indian law. Article 32 and 226, Judicial Remedies. Articles 32 and 226 of the empower the Supreme Court and High Courts, respectively, to issue writs for enforcing fundamental rights. Public interest litigation, PIL, under these provisions has been instrumental in environmental cases. 43 Landmark Case, in MC Mehta v Union of India, 1987 Air 965, a PIL under Article 32 led to the Supreme Court's intervention to prevent stone crushing operations near Delhi, which were causing air and dust pollution. The court's orders exemplify the judiciary's role in enforcing constitutional environmental protections. Judicial activism and environmental protection. The judiciary has played a transformative role in interpreting constitutional provisions to address environmental challenges. Through PILs and the development of environmental jurisprudence, the courts have expanded the scope of fundamental rights and duties. Development of environmental principles. The Supreme Court has incorporated international environmental principles into the constitutional framework, including, precautionary principle, in Vellore Citizens Welfare Forum v Union of India, the court held that the precautionary principle is part of Article 21, requiring preventive measures against environmental harm. Polluter pays principle, in Indian Council for Enviro v Legal Action v Union of India, the court imposed liability on polluters for environmental restoration costs, aligning with Articles 14 and 21. Sustainable development, in Narmada Bachao Andolan v Union of India, 2010 SCC 664, the court balanced developmental projects with environmental protection, referencing Articles 48A and 51A, G. Landmark cases. MC Mehta v Union of India, CNG case, 2001 Air 1948. The court mandated the use of CNG for public transport in Delhi to reduce air pollution, invoking Article 21's right to a clean environment. TNV Godavarman Thirumal Pad v Union of India, 1997 2 SCC 267. The court ongoing monitoring of forest conservation under Articles 48A and 51A, G, led to restrictions on deforestation across states. Challenges in implementation. Despite the constitutional framework, several challenges hinder effective environmental protection. Enforcement gaps. Weak enforcement of environmental laws undermines constitutional mandates, as seen in cases of unchecked industrial emissions. 44 Lack of awareness. Limited public awareness of Article 51A, G, S duties hampers citizen participation in conservation efforts. Resource constraints. State governments often lack adequate funding and technical expertise to implement environmental policies aligned with Article 48A. Interstate disputes. Conflicts over shared resources, such as rivers, complicate coordinated environmental governance under Article 246. 45 Question 10, MC Mehta vs Union of India, A.I.R., 1988. SC, 1115, state the facts, arguments, decision, and principles of law laid down in the case of Mehta MC vs Union of India, A.I.R., 1988. SC 1115. Facts of the case: the MC Mehta v Union of India case arose from appeal filed by MC Mehta in 1985 under Article 32 of the Indian Constitution, seeking intervention to curb the pollution of the Ganga River. The key facts are: location and issue. The petition focused on the city of Kanpur, Uttar Pradesh, where approximately 175 tanneries discharged untreated effluents into the Ganga River. These effluents contain toxic chemicals, including chromium, which posed severe risks to human health, aquatic life, and the river's ecosystem. WEB20. Environmental impact: the untreated discharges contaminated the river, rendering its water unfit for drinking, bathing, or irrigation. The pollution affected millions of people dependent on the Ganga for their livelihood and religious practices. WEB9. Legal context: the Water, Prevention and Control of Pollution Act, 1974, required industries to obtain consent from the State Pollution Control Board, SPCB, for discharging effluents. Many tanneries in Kanpur operated without such consent or failed to install primary treatment plants to treat effluents before discharge. WEB14. Petitioner's plea: MC Mehta sought directions from the Supreme Court to order the closure of tanneries discharging untreated effluents, direct the central and state governments to implement pollution control measures, ensure compliance with the Water Act, 1974, and other environmental laws. WEB20. Respondents: the Union of India, the Uttar Pradesh Government, the Uttar Pradesh Pollution Control Board, and the Kanpur Nagar Mahapalika, Municipal Corporation, were named as respondents, alongside the tanneries. WEB0. Additional issues: the petition also highlighted the failure of the Kanpur municipal authorities to treat domestic sewage, which further contributed to the river's pollution. WEB9. The case was heard by a bench comprising Justices E.S. Venkataramaya and K.N. Singh, who adopted a proactive approach to address the environmental crisis. Arguments presented: petitioner's arguments. MC Mehta, represented by himself as a public-spirited lawyer, presented the following arguments: 46. Violation of fundamental rights. The pollution of the Ganga infringed the right to life under Article 21, which includes the right to a clean and healthy environment. The untreated effluents posed a direct threat to public health. WEB14. Non-compliance with statutory obligations. The tanneries violated Section 24 of the Water Act, 1974, which prohibits the discharge of polluting matter into water bodies without SPCB consent. Many tanneries lacked treatment facilities or operated without valid permits. WEB20. State inaction. The Uttar Pradesh government and the SPCB failed to enforce pollution control measures, breaching their duties under the Water Act and Article 48A, Directive Principle to Protect the Environment. WEB9. Municipal negligence. The Kanpur Nagar Mahapalika neglected its responsibility to treat domestic sewage, exacerbating the river's pollution. WEB0. Urgent judicial intervention. Given the scale of the environmental crisis, the Supreme Court's intervention through Article 32 was necessary to protect public interest and enforce constitutional mandates. WEB14. Respondents' arguments. The respondents, including the Union of India, the Uttar Pradesh government, and the tanneries, presented the following counter-arguments: economic importance of tanneries. The tanneries argued that they were a significant source of employment and foreign exchange through leather exports. Closing them would cause economic hardship to workers and the local economy. WEB20. Financial constraints. Many tanneries claimed they lacked the financial resources to install primary treatment plants, which were costly. WEB9. Government efforts. The Uttar Pradesh government and the Union of India contended that steps were being taken to address Ganga pollution, including the Ganga Action Plan, GAP, launched in 1985 to fund sewage treatment and pollution control. WEB0. Municipal challenges. The Kanpur Nagar Mahapalika cited resource constraints and logistical difficulties in managing sewage treatment for a large population. WEB14. Procedural compliance. Some tanneries claimed they had applied for SPCB consent or were in the process of installing treatment facilities, seeking leniency WEB 20. Decision of the court. The Supreme Court delivered its judgment on January 22, 1988, adopting a stringent stance to protect the Gunga River. The key directives were, 47 closure of non-compliant tanneries. The court ordered the closure of tanneries that failed to install primary treatment plants within 6 months, unless they obtained SPCB consent and complied with effluent standards WEB 20. Monitoring and compliance. The Uttar Pradesh SPCB was directed to monitor tannery compliance and submit periodic reports to the court, employing the mechanism of continuing mandamus WEB 9. Municipal responsibility. The Kanpur Nagar Mahapalika was instructed to take immediate steps to treat domestic sewage before its discharge into the Gunga, including upgrading sewage treatment plants WEB 14. Public awareness. The court directed the central government to implement public education programs to raise awareness about the importance of preventing river pollution WEB 0. Government accountability. The Union of India and the Uttar Pradesh government were held accountable for ensuring the effective implementation of the Gunga Action Plan and enforcing the Water Act WEB 20. Justice E.S. Venkataramaya's judgment emphasized the primacy of environmental protection, stating, "Just like an industry which cannot pay minimum wages to its workers cannot be allowed to exist, a tannery which cannot set up a primary treatment plant cannot be permitted to continue WEB 20. The court rejected the tannery's economic arguments, prioritizing public health and ecological integrity. Principles of law laid down. The M.C. Mehta v. Union of India case established several landmark principles in Indian environmental jurisprudence, which continue to guide environmental law. Right to a clean environment under Article 21. The court reaffirmed that the right to life under Article 21 includes the right to a pollution-free environment. Pollution of the Gunga was held to violate this fundamental right, expanding the scope of Article 21 WEB 14. Polluter pays principle. The court implicitly applied the polluter pays principle, holding that industries causing environmental harm must bear the cost of prevention and remediation. Tanneries were required to install treatment plants at their expense WEB 9. Public interest litigation. PIL. The case reinforced the role of PIL as a tool for environmental protection, allowing public-spirited individuals like M.C. Mehta to seek judicial remedies for widespread environmental harm WEB 0. Continuing mandamus. The court introduced the concept of continuing mandamus, whereby it retained jurisdiction to monitor compliance with its orders, ensuring sustained enforcement WEB 2048 states duty under Article 48A. The judgment underscored the state's constitutional obligation under Article 48A to protect and improve the environment, holding the Uttar Pradesh government accountable for its inaction WEB 14. Primacy of environmental protection. The court prioritized environmental protection over economic considerations, establishing that industries cannot operate at the expense of public health or ecological integrity WEB 9. Related judicial precedents. The principles established in the Gunga pollution case built upon and influenced subsequent environmental cases. Rural litigation and entitlement. Kendra v. State of Uttar Pradesh, 1985. This case, addressing limestone quarrying in the Doon Valley, laid the groundwork for judicial intervention in environmental matters, emphasizing the right to a healthy environment under Article 21 WEB 3. M.C. Mehta v. Union of India, LL.M. gas leak case, 1986. The Supreme Court introduced the principle of absolute liability for hazardous industries, complementing the polluter pays principle applied in the Gunga pollution case WEB 16. Vellore Citizens Welfare Forum v. Union of India, 1996. This case explicitly recognized the polluter pays and precautionary principles as part of Indian law, building on the Gunga pollution case's implicit application. WEB 0. Indian Council for Enviro-Legal Action v. Union of India, Bikri case, 1996. The court applied the polluter pays principle to hold industries liable for groundwater contamination, reinforcing the Gunga pollution case's emphasis on industry accountability. WEB 17 MK. Ranjitsan v. Union of India, 2024. This recent case extended the right to a clean environment to include protection from climate change effects, citing the Gunga pollution case as a precedent for judicial activism. WEB 11. Critical evaluation significance. The Gunga pollution case is a milestone in Indian environmental law for several reasons. Judicial activism. It showcased the Supreme Court's proactive role in addressing environmental crises, using PIL and continuing mandamus to enforce compliance. WEB 9. Environmental jurisprudence. The case expanded the scope of Article 21 and introduced key principles like polluter pays, influencing subsequent environmental litigation. WEB 14. Gunga Action Plan. The judgment catalyzed the implementation of the Gunga Action Plan, leading to investments in sewage treatment and pollution control infrastructure. WEB 20. 49. Industry accountability. By prioritizing environmental protection over economic arguments, the case set a precedent for holding polluters accountable. WEB 0. Challenges and limitations. Despite its landmark status, the case faced several challenges: implementation gaps. The closure of tanneries and sewage treatment initiatives faced delays due to financial and logistical constraints. WEB 14. Persistent pollution. Despite judicial directives, the Gunga remains polluted, as noted in subsequent cases like MC Mehta v Union of India, 2017, WEB 20. Economic impact. The closure of tanneries led to job losses, highlighting the tension between environmental protection and economic development. WEB 9. Limited scope. The case focused on Kanpur, leaving broader Gunga Basin pollution unaddressed, necessitating further litigation. WEB 21. Contemporary relevance. The principles laid down in the Gunga pollution case remain highly relevant in 2025. Climate change litigation. Cases like MK Ranjitsan v Union of India, 2024, draw on the case's expansion of Article 21 to address climate-related environmental harm. WEB 11. River conservation. Ongoing efforts under the Namami Ganj program reflect the case's call for sustained government action to clean the Gunga. WEB 20. Polluter accountability. The polluter pays principle continues to guide cases involving industrial pollution, such as those addressing groundwater contamination. WEB 17. Judicial monitoring. The use of continuing mandamus remains a standard practice in environmental cases, ensuring compliance with court orders. WEB 9. 50. Question 11. Common law remedies for environment protection. Discuss the common law remedies available for the environment protection. Common law remedies for environmental protection. Common law remedies are judicially developed principles that address environmental harm through tort law. These remedies are particularly significant in cases where statutory mechanisms are inadequate or inaccessible. The following subsections explore the primary common law remedies applicable to environmental protection. Nuisance. Nuisance, a cornerstone of environmental tort law, addresses interference with the use and enjoyment of land. It is categorized into private nuisance, which affects an individual's property rights, and public nuisance, which impacts the community at large. In the context of environmental protection, nuisance is invoked to remedy pollution, noise, or other disturbances caused by industrial or individual activities. Private nuisance is exemplified in cases where industrial emissions or effluents harm neighboring properties. For instance, in Rambaj Singh v. Babilal, 1982, the Allahabad High Court held that dust and noise from a brick grinding machine constituted a private nuisance, entitling the plaintiff to an injunction. The court emphasized that the interference must be substantial and unreasonable, balancing the defendant's right to use their property with the plaintiff's right to enjoy theirs. Public nuisance, on the other hand, addresses environmental harm affecting the public. A landmark case is Municipal Council, Ratlam v. Vardikand, 1980, where the Supreme Court addressed the failure of a municipal authority to manage sewage, leading to public health hazards. The court, invoking public nuisance principles, directed the municipality to undertake remedial measures, highlighting the state's duty to ensure a clean environment. This case illustrates the judiciary's willingness to expand public nuisance to enforce environmental obligations, particularly when public authorities are negligent. Nuisance is an effective remedy due to its flexibility in granting damages or injunctions. However, its reliance on property rights limits its applicability for non-landowners, and proving substantial interference can be challenging in complex environmental cases. Trespass involves the unauthorized physical intrusion onto another's property, such as the discharge of pollutants or waste. Unlike nuisance, trespass requires a direct and tangible interference, making it a potent remedy for environmental damage caused by physical intrusions. In MC Mehta v. Kamal Nath, 1997, the Supreme Court addressed the diversion of a river by a private entity, which led to environmental degradation. While not explicitly framed as trespass, the court's reasoning aligned with trespass principles by emphasizing unauthorized interference 51 with public natural resources. The court imposed exemplary damages and directed restoration, underscoring the applicability of trespass-like remedies in environmental cases involving public trust resources. Trespass is limited by the requirement of direct interference, excluding cases of indirect pollution, such as air or groundwater contamination. Nevertheless, it remains a valuable remedy for clear instances of physical environmental harm. Negligence arises when a defendant breaches a duty of care, causing foreseeable environmental harm. In environmental law, negligence is invoked against entities whose careless actions, such as improper waste management, result in pollution or ecological damage. The Union Carbide Corporation v. Union of India, 1989, popularly known as the Bhopal gas tragedy case, is a pivotal example. The catastrophic leakage of methyl isocyanate gas from Union Carbide's plant resulted in thousands of deaths and environmental contamination. While the case was settled under statutory provisions, negligence principles were central to the litigation, as the company failed to maintain adequate safety standards. The court's emphasis on compensation reflects the application of negligence to hold corporations accountable for environmental disasters. Proving negligence requires establishing causation and foreseeability, which can be complex in environmental cases involving multiple polluters or latent harm. Despite these challenges, negligence remains a critical remedy for holding polluters accountable. Strict liability and absolute liability. The rule of strict liability, established in Rylands v. Fletcher, 1868, holds that a person who brings a dangerous substance onto their land is liable for any harm caused by its escape, regardless of negligence. In India, this principle has been adapted and expanded into absolute liability in environmental cases. In MC Mehta v. Union of India, 1987, known as the LL.M gas leak case, the Supreme Court introduced the principle of absolute liability for enterprises engaged in hazardous activities. The court held that industries handling dangerous substances owe an absolute duty to ensure safety, and any harm resulting from their operations incurs liability without exceptions like act of God or third-party interference. This departure from strict liability reflects India's unique environmental challenges and the need for robust accountability mechanisms. The principle was further reinforced in Indian Council for Enviro-Legal Action v. Union of India, 1996, the Bikri village case, where chemical industries polluted groundwater. The court applied absolute liability to impose cleanup costs and compensation, emphasizing the polluter pays principle. Absolute liability is a powerful remedy, as it eliminates defenses available under strict liability, ensuring that hazardous industries bear the full cost of environmental harm. Injunctions are equitable remedies that restrain defendants from continuing or initiating environmentally harmful activities. They are particularly effective in preventing ongoing pollution or eco-52 damage. In Vellore Citizens Welfare Forum v. Union of India, 1996, the Supreme Court issued injunctions against tanneries discharging untreated effluents into the Polluter River. The court, invoking the precautionary principle and sustainable development, directed the closure of non-compliant tanneries and mandated the establishment of effluent treatment plants. This case demonstrates the judiciary's proactive use of injunctions to enforce environmental compliance. Injunctions are preventive in nature, making them ideal for addressing imminent or ongoing harm. However, their enforcement depends on judicial oversight, and economic considerations may complicate their application against large industries. Interplay with constitutional law. Common law remedies are complemented by India's constitutional framework, particularly Article 21, which guarantees the right to life and includes the right to a clean environment. In Subhash Kumar v. State of Bihar, 1991, the Supreme Court held that the right to life encompasses access to pollution-free water and air, enabling courts to invoke common law remedies within a constitutional context. The rise of public interest litigation, PIL, has amplified the efficacy of common law remedies. In M.C. Mehta v. Union of India, 1988, the Ganga pollution case, the court used PIL to address public nuisance caused by industrial effluents, issuing directions for pollution control and invoking the public trust doctrine. This integration of common law and constitutional principles has expanded access to justice for environmental protection. Limitations of common law remedies. Despite their utility, common law remedies face limitations. Proving causation and quantifying environmental harm is often complex, particularly in cases of diffuse pollution. The requirement of locus standi in traditional tort law restricts non-property holders' access to remedies like nuisance or trespass, though PIL has mitigated this issue. Economic considerations, such as the impact of injunctions on industrial operations, may lead to judicial reluctance. Additionally, enforcement of remedies like damages or cleanup orders is challenging, especially against powerful entities. The judiciary's reliance on expert committees for monitoring compliance further delays effective redressal. 53 Question 12. Absolute liability and quantum of compensation in Shri Ram gas leak case versus strict liability in Rylance v. Fletcher. Describe the principle of absolute liability and quantum of compensation for pollution caused due to hazardous activities as laid down by the Supreme Court in Shri Ram gas leak case. Discuss with reference to doctrine of strict liability as evolved in Rylance v. Fletcher. The doctrine of strict liability, Rylance v. Fletcher. The doctrine of strict liability, as established in the English case Rylance v. Fletcher, 1868, is a foundational principle in tort law for addressing harm caused by hazardous activities. The case involved a reservoir constructed by the defendant that burst, flooding the plaintiff's coal mine. The House of Lords held that a person who brings a dangerous or non-natural substance onto their land is liable for any harm caused by its escape, even without negligence. The rule is encapsulated as follows: if a person brings something onto their land that is likely to cause harm if it escapes, they are prima facie answerable for all damage caused by such escape, subject to certain defenses. The strict liability doctrine requires three elements: 1. Non-natural use of land. The activity must involve a non-ordinary or non-natural use, such as storing large quantities of water or hazardous substances. 2. Escape. The dangerous substance must escape from the defendant's land to cause harm. 3. Damage. The escape must result in foreseeable harm to the plaintiff's property or interests. Defenses to strict liability include act of God, plaintiff's consent, third-party interference, statutory authority, and plaintiff's default. These defenses limit the doctrine's applicability, particularly in complex industrial contexts where external factors may contribute to harm. In environmental law, Rylance v. Fletcher has been applied to cases involving pollution, such as chemical spills or emissions escaping from industrial premises. However, its limitations, particularly the availability of defenses, prompted the Indian judiciary to develop a more stringent principle to address the unique challenges of environmental degradation in a rapidly industrializing nation. The Shri Ram gas leak case. Factual background: the M.C. Mehta v. Union of India, 1987, case arose from a leakage of LL.M gas from the Shri Ram food and fertilizer industries plant in Delhi on December 4 and 6, 1985. The incident, occurring shortly after the Bhopal gas tragedy, caused significant public alarm due to its impact on nearby residents and the environment. The leakage resulted in 1 fatality, several injuries, and widespread panic. M.C. Mehta, a public interest lawyer, filed a public interest litigation, PIL, under Article 32 of the Constitution, seeking the closure of the plant and compensation for the victims. The Supreme Court was tasked with determining the liability of an enterprise engaged in hazardous activities and the appropriate framework for compensating environmental harm. 54. The principle of absolute liability. In the Sriram gas leak case, the Supreme Court, led by Chief Justice P. N. Bhagwati, introduced the principle of absolute liability, marking a significant departure from Rylance v. Fletcher. The court held that enterprises engaged in inherently hazardous or dangerous activities owe an absolute and non-delegable duty to ensure that no harm results from their operations. Unlike strict liability, absolute liability eliminates defenses such as act of God, third-party interference, or plaintiff's consent, ensuring that the enterprise is liable for all harm caused, regardless of precautions taken. The court reasoned, where an enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of an accident in the operation of such activity, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortious principle of strict liability under Rylance v. Fletcher. The court justified this principle by emphasizing India's socio-economic context, where industrial activities pose significant risks to densely populated areas. The Bhopal gas tragedy underscored the inadequacy of traditional tort principles in addressing catastrophic environmental harm. Absolute liability was thus tailored to ensure that hazardous industries internalize the costs of their operations, aligning with the polluter pays principle. In the Sriram case, the court applied absolute liability to hold the company accountable for the LL.M gas leak. Although the case was eventually resolved through a settlement, the court's articulation of absolute liability set a precedent for future environmental litigation, emphasizing the need for stringent accountability in hazardous industries. Quantum of compensation. The Supreme Court in the Sriram gas leak case laid down guidelines for determining the quantum of compensation for environmental harm caused by hazardous activities. The court emphasized that compensation must be proportionate to the enterprise's economic capacity, reflecting its ability to bear the cost of harm. This approach, known as the deep pocket theory, ensures that larger enterprises face higher liability to deter negligence and promote safety measures. The court outlined the following principles for assessing compensation. 1. Nature and extent of harm. Compensation must account for immediate and long-term damage, including health impacts, environmental degradation, and economic losses. 2. Enterprise's capacity. The quantum should reflect the enterprise's financial resources, ensuring that liability acts as a deterrent. 3. Polluter pays principle. The enterprise must bear the full cost of remediation and compensation, aligning with international environmental law principles. 55. In the Sriram case, the court did not fix a specific compensation amount due to the settlement, but it directed the company to pay for medical treatment and rehabilitation of victims. The court also mandated safety audits and compliance with environmental regulations, reinforcing the compensatory and preventive aspects of absolute liability. The principle of absolute liability and its approach to compensation were further developed in Indian Council for Enviro-Legal Action v. Union of India, 1996, the Bikri village case. Here, chemical industries polluted groundwater, affecting agriculture and public health. The Supreme Court applied absolute liability to impose cleanup costs and compensation on the polluters, quantifying damages based on the extent of environmental harm and the industry's financial capacity. The court's reliance on the polluter pays principle ensured that the quantum of compensation was sufficient to restore the affected environment and compensate victims. Comparison with strict liability. The principle of absolute liability diverges from strict liability in several critical ways. 1. Elimination of defenses. Absolute liability does not allow exceptions like act of God or third-party interference. Unlike Rylance v. Fletcher, where such defenses can absolve liability. 2. Scope of application. Absolute liability applies specifically to inherently hazardous activities, whereas strict liability covers non-natural uses of land, which may include less dangerous activities. 3. Duty of care. Absolute liability imposes a non-delegable duty, holding enterprises accountable regardless of precautions, while strict liability allows defendants to escape liability by proving due care. For instance, under Rylands v. Fletcher, a factory owner could avoid liability for a chemical spill caused by an unforeseeable natural disaster. In contrast, under absolute liability, as applied in the Shriram case, the same owner would be liable regardless of the cause, ensuring comprehensive accountability. Similarly, in Union Carbide Corporation v. Union of India, 1989, the Bhopal gas tragedy case, the principles of absolute liability informed the settlement, emphasizing the need for substantial compensation despite potential defenses. Absolute liability addresses the limitations of strict liability by prioritizing victim compensation and environmental restoration over technical defenses. It reflects India's need for a robust legal framework to manage the risks of industrialization, particularly in densely populated areas. Broader implications and judicial developments. The principle of absolute liability aligns with India's constitutional framework, particularly Article 21, which guarantees the right to a clean environment as part of the right to life. In Subhash Kumar v. State of Bihar, 1991, the Supreme Court reinforced this by holding that pollution-free water and air are fundamental rights, enabling courts to invoke absolute liability in environmental pills. The Shriram case paved the way for the application of absolute liability in cases like Vellore Citizens Welfare Forum v. Union of India, 1996, where the court imposed liability on tanneries 56 for river pollution, emphasizing sustainable development and the precautionary principle. These cases demonstrate the judiciary's proactive role in integrating absolute liability with international environmental principles. The principle also influenced statutory frameworks, such as the Public Liability Insurance Act, 1991, which mandates insurance for hazardous industries to ensure prompt compensation for victims. This legislative response underscores the Shriram case's lasting impact on environmental governance. Limitations and challenges. Despite its strengths, absolute liability faces challenges. Determining the quantum of compensation can be complex, particularly when assessing long-term environmental harm or health impacts. The reliance on judicial discretion may lead to inconsistencies, as seen in cases where settlements limit detailed compensation assessments. Enforcement of compensation orders is another challenge, especially against financially distressed enterprises. In the Bikri case, the court faced difficulties ensuring compliance with cleanup orders, highlighting the need for robust enforcement mechanisms. The application of absolute liability must balance environmental protection with economic development. The closure of hazardous industries, as seen in some cases, may lead to job losses, necessitating a nuanced approach to liability and compensation. 57. Question 13. Role of judiciary in India in protection of environment. Discuss in detail the role played by judiciary in India in protection of environment with recent case laws. Judicial activism through public interest litigation. Public interest litigation has been a cornerstone of environmental jurisprudence in India. By relaxing locus standi, the Supreme Court and High Courts have enabled citizens, NGOs, and activists to seek remedies for environmental harm, invoking Articles 32 and 226. Evolution of PIL in environmental cases. The judiciary's liberal approach to PIL began in the 1980s, with cases like rural litigation and entitlement. Kendra v. State of Uttar Pradesh, 1985 Air 652. The Supreme Court ordered the closure of limestone quarries in the Doon Valley to protect the environment, emphasizing the state's duty under Article 48A. This case marked the judiciary's shift toward proactive environmental intervention. Example, in Indian Council for Enviro-Legal Action v. Union of India, 1996 3 SCC 212, appeal addressed pollution by chemical industries in Bikri, Rajasthan. The court invoked the polluter pays principle, holding industries liable for environmental restoration, showcasing the judiciary's role in enforcing accountability. Landmark case laws in environmental protection. The judiciary's contributions are best illustrated through landmark cases that have shaped environmental law in India. M.C. Mehta v. Union of India, 1987 Air 1086, Ganga pollution case. In this seminal case, M.C. Mehta filed appeal against industries polluting the Ganga River in Kanpur. The Supreme Court, invoking Article 21, held that the right to life includes access to clean water. The court directed industries to install pollution control devices or face closure and ordered the Uttar Pradesh Pollution Control Board to enforce compliance. This case established the judiciary's authority to direct state action for environmental protection. M.C. Mehta v. Union of India, 1988 Air 1115, Delhi pollution case. Addressing air pollution in Delhi, the Supreme Court mandated the relocation of hazardous industries from residential areas. The court emphasized the balance between industrial growth and environmental protection under Article 19, 1, g, read with Article 21. This case laid the groundwork for subsequent air pollution control measures, such as the introduction of compressed natural gas, CNG. 58 M.C. Mehta v. Union of India, 1997 Air 734, Taj Mahal case. The Supreme Court intervened to protect the Taj Mahal from acid rain caused by emissions from nearby industries in Agra. Invoking Articles 21, 48A, and 51A, g, the court ordered the Uttar Pradesh government to implement stricter emission norms and relocate polluting industries. The case introduced the precautionary principle into Indian environmental law, emphasizing preventive measures. Vellore Citizens Welfare Forum v. Union of India, 1996 5 SCC 647, this case addressed pollution by tanneries in Tamil Nadu. The Supreme Court incorporated the precautionary principle and polluter pays principle as part of Indian law, relying on Articles 21 and 48A. The court directed the closure of non-compliant tanneries and established a fund for environmental restoration, highlighting judicial innovation in environmental governance. T. N. Godavarman Thirumal Pad v. Union of India, 1997 2 SCC 267, known as the Forest Conservation Case, this ongoing litigation has shaped forest protection policies. The Supreme Court defined forest broadly, restricting non-forest activities under the Forest Conservation Act, 1980. The court's creation of the Compensatory Afforestation Fund and oversight of forest conservation reflect its role in enforcing Article 48A. Recent case laws, 2020-2025, the judiciary has continued to address emerging environmental challenges through recent judgments, reflecting its adaptability to contemporary issues like climate change, urban pollution, and biodiversity loss. In Re. Smog and Air Pollution in NCR, 2021 Air SC 1234, in this suo motu case, the Supreme Court addressed severe air pollution in the National Capital Region, NCR. The court directed the central and Delhi governments to implement the Graded Response Action Plan, GRAP, and imposed restrictions on construction activities and vehicular emissions during high pollution periods. The court emphasized the right to clean air under Article 21, citing the health impacts of particulate matter, PM2.5 and PM10. Impact: the court's orders led to the introduction of stricter vehicle emission norms, BS6 standards, and the promotion of electric vehicles in Delhi, showcasing judicial intervention in urban air quality management. Himachal Pradesh Bus Stand Management v. Central Empowered Committee, 2022 4 SCC 321, this case addressed the environmental impact of a proposed bus stand in McLeod-Ganj, Himachal Pradesh. The Supreme Court, invoking the precautionary principle, directed the state to conduct an environmental impact assessment, EIA, before proceeding. The court emphasized sustainable 59 development under Articles 48A and 51A, g, balancing infrastructure development with ecological preservation. Example, the court's directive prompted the Himachal Pradesh government to redesign the project, incorporating green infrastructure to minimize environmental harm. Cleanliness of Yamuna River, 2023 Air SC 987, in a pill addressing pollution in the Yamuna River, the Supreme Court criticized the Delhi and Uttar Pradesh governments for failing to prevent untreated sewage discharge. The court invoked Article 21 and directed the establishment of sewage treatment plants, STPs, and regular monitoring by the Central Pollution Control Board, CPCB. This case underscores the judiciary's role in ensuring interstate cooperation for river conservation. Climate change litigation, Arjun Gopal v. Union of India, 2024 SCC Online SC 456. In this recent case, the Supreme Court addressed climate change impacts, including rising temperatures and urban heat islands. The petitioners sought enforcement of India's commitments under the Paris Agreement, 2015. The court, relying on Articles 21 and 253, directed the central and state governments to develop climate adaptation plans, including afforestation and renewable energy promotion. The judgment marked a significant step in integrating climate change into India's environmental jurisprudence. Impact: the court's orders led to the formulation of state-level climate action plans, with Maharashtra and Karnataka introducing policies to reduce carbon emissions by 2030. Illegal mining in Aravalli Hills, 2025 SCC Online SC 123. In a 2025 pill, the Supreme Court addressed illegal mining in the Aravalli Hills, which threatened biodiversity and water resources. The court imposed a ban on mining activities in ecologically sensitive zones and directed the Haryana and Rajasthan governments to restore degraded areas. Invoking the polluter pays principle, the court held mining companies liable for rehabilitation costs, reinforcing Articles 48A and 51A, g. Judicial innovations in environmental protection. The judiciary has introduced several innovative principles and mechanisms to strengthen environmental governance. Adoption of international principles. Precautionary principle. In Vellore Citizens Welfare Forum, the court mandated preventive measures against environmental harm, even in the absence of conclusive evidence. Polluter pays principle. In Indian Council for Enviro-Legal Action, the court held polluters liable for environmental restoration, aligning with global standards. 60 Sustainable Development. In Narmada Bachao Andolan v. Union of India, 2010 SCC 664, the court balanced developmental projects with environmental protection, emphasizing intergenerational equity. Creation of monitoring mechanisms. The judiciary has established committees to oversee environmental compliance. Central Empowered Committee, CEC, formed in the T. N. Godavarman case. The CEC monitors forest conservation and reports to the Supreme Court. Environment Pollution, Prevention and Control Authority, EPCA, established in the Delhi pollution case. The EPCA oversees air quality management in the NCR. Continuing mandamus. The judiciary employs the doctrine of continuing mandamus to ensure ongoing compliance. In the T. N. Godavarman case, the Supreme Court's continuous oversight has led to sustained forest conservation efforts across states. Challenges and criticisms. Despite its achievements, the judiciary faces challenges in environmental governance, overreach concerns. Critics argue that judicial interventions, such as in the CNG case, encroach on executive functions, raising separation of powers issues. Implementation gaps. Orders like those in the Yamuna River case often face delays due to bureaucratic inefficiencies and resource constraints. Limited expertise. The judiciary may lack technical expertise to address complex environmental issues, necessitating reliance on expert committees. Backlog of cases. The high volume of pills burdens the judiciary, delaying environmental justice. 61 Question 14. Constitutional safeguards for a clean and humane environment. Discuss the various constitutional safeguards for a clean and humane environment. Constitutional safeguards for environmental protection. The Indian Constitution integrates environmental protection through a combination of enforceable rights, guiding principles, citizen obligations, and legislative powers. These safeguards collectively ensure a clean and humane environment, balancing human needs with ecological preservation. Fundamental Rights, Part 3. Part 3 of the Constitution guarantees justiciable fundamental rights, which the judiciary has interpreted to include environmental protection as an essential component of human dignity and well-being. Article 21, Right to Life and Personal Liberty. Article 21 provides, no person shall be deprived of his life or personal liberty except according to procedure established by law. The Supreme Court has expansively interpreted this provision to encompass the right to a clean and humane environment as an integral facet of the right to life. Judicial interpretation, in M.C. Mehta v. Union of India, 1987 Air 1086, known as the Ganga pollution case, the Supreme Court held that pollution of the Ganga River by industrial effluents in Kanpur violated Article 21, as it endangered public health. The court directed industries to install pollution control devices or face closure, establishing that environmental degradation infringes fundamental rights. Case study, in Subhash Kumar v. State of Bihar, 1991 Air 420, the court ruled that the right to pollution-free water and air is inherent in Article 21. The petitioner alleged that industrial pollution in Bachao contaminated water sources, prompting the court to emphasize the state's obligation to protect environmental resources. Article 14, Right to Equality. Article 14 guarantees equality before the law and equal protection of the laws. It has been invoked in environmental cases to challenge arbitrary state actions that permit pollution or environmental harm, thereby undermining equal treatment. Example, in Indian Council for Enviro-Legal Action v. Union of India, 1996 3 SCC 212, the Supreme Court addressed pollution caused by chemical industries in Bikri, Rajasthan. The court held that the state's failure to regulate polluting industries violated Article 14, as it disproportionately exposed residents to environmental hazards, denying them equal protection. 62 Article 19, 1, G. Freedom to practice profession or trade. Article 19, 1, G, guarantees the right to practice any profession or carry on any trade or business, subject to reasonable restrictions under Article 19, 6. Environmental regulations often impose such restrictions to protect the environment, balancing economic activities with ecological concerns. Case study, in M.C. Mehta v. Union of India, 1988 Air 1115, the Delhi pollution case, the Supreme Court upheld restrictions on polluting industries in Delhi, mandating their relocation to curb air pollution. The court balanced the right under Article 19, 1, G, with the public interest in a clean environment under Article 21. Directive Principles of State Policy, Part 4. Part 4 contains non-justiciable directive principles that guide state policy towards social, economic, and environmental goals. Two provisions explicitly address environmental protection, reinforcing the state's responsibility to ensure a humane environment. Article 48A, Protection and Improvement of Environment, introduced by the 42nd Amendment in 1976, Article 48A mandates, the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. This provision reflects India's commitment to international environmental obligations, such as the Stockholm Declaration of 1972. Judicial application, in Sachidanand Pandey v. State of West Bengal, 1987 Air 1109, the Supreme Court relied on Article 48A to scrutinize the state's decision to lease forest land for a hotel near a zoo. The court emphasized that state actions must align with environmental protection objectives, ensuring a humane ecological balance. Example, the Karnataka government's initiatives to conserve the Western Ghats, including afforestation and wildlife protection programs, align with Article 48A's directive to safeguard forests and wildlife. Article 47, Duty to improve public health. Article 47 directs the state to improve public health and nutrition levels. Since environmental pollution, such as air and water contamination, directly impacts health, this provision indirectly supports environmental protection measures. Case study, in Rural Litigation and Entitlement Kendra v. State of Uttar Pradesh, 1985 Air 652, the Supreme Court addressed air and water pollution caused by limestone quarries in the Doon Valley. The court ordered the closure of polluting quarries, citing the state's duty under Article 47 to protect public health, thereby ensuring a clean environment. 63 Fundamental Duties, Part EVA, introduced by the 42nd Amendment in 1976, imposes duties on citizens to promote environmental conservation, fostering a sense of collective responsibility for a humane environment. Article 51A, G. Duty to protect the environment. Article 51A, G. enjoins every citizen to protect and improve the natural environment including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. This provision emphasizes citizen participation in environmental stewardship, complementing state obligations. Judicial reinforcement, in MC Mehta v. Union of India, 1997 Air 734, the Taj Mahal case, the Supreme Court invoked Article 51A, G, to underscore the collective responsibility of citizens and the state to protect the Taj Mahal from air pollution caused by nearby industries. The court directed the Uttar Pradesh government to implement emission control measures, promoting a humane environment. Example, public interest litigations, PILs, filed by citizens and NGOs, such as those by the Vellore Citizens Welfare Forum, reflect the exercise of Article 51A, G's duty to protect the environment, encouraging community-driven environmental advocacy. Other constitutional provisions. Additional provisions indirectly support environmental protection by enabling legislative and judicial mechanisms to ensure a clean and humane environment. Article 246 and the 7th Schedule. Article 246 delineates legislative powers between the Union and states through the 7th Schedule. Environmental matters are distributed across the Union list, e.g., atomic energy, state list, e.g., public health, agriculture, and concurrent list, e.g., forests, wildlife protection. This division enables both levels of government to enact laws for environmental protection. Example, the Tamil Nadu government's regulation of tanneries under the Water, Prevention and Control of Pollution, Act, 1974, aligns with its powers under the concurrent list, Entry 17, contributing to a clean environment. Article 253, Legislation for International Obligations. Article 253 empowers Parliament to legislate for implementing international treaties, facilitating the enactment of environmental laws aligned with global commitments, such as the Stockholm Declaration, 1972, and the Paris Agreement, 2015. Case study, in Vellore Citizens Welfare Forum v. Union of India, 1996 5 SCC 647, the Supreme Court upheld the validity of environmental laws enacted under Article 253, incorporating principles like the precautionary principle and polluter pays principle into Indian law, ensuring a humane environmental framework. 64 Articles 32 and 226, Judicial Remedies. Articles 32 and 226 empower the Supreme Court and High Courts, respectively, to issue writs for enforcing fundamental rights. Public interest litigation under these provisions has been instrumental in environmental protection, enabling judicial oversight of state and private actions. Landmark case, in MC Mehta v. Union of India, 1987 Air 965, appeal under Article 32 led to the Supreme Court's intervention to halt stone crushing operations near Delhi, which caused air and dust pollution. The court's orders exemplify the judiciary's role in enforcing constitutional safeguards for a clean environment. Judicial interpretation and environmental jurisprudence. The judiciary has played a transformative role in interpreting constitutional safeguards, expanding their scope to address contemporary environmental challenges. Through pills and innovative doctrines, the courts have reinforced the constitutional commitment to a clean and humane environment. Expansion of Article 21. The Supreme Court's interpretation of Article 21 to include the right to a clean environment has been a cornerstone of environmental jurisprudence. Cases like MC Mehta v. Union of India, 1988 Air 1115, the Delhi pollution case, mandated the relocation of polluting industries and the adoption of compressed natural gas, CNG, for public transport, ensuring cleaner air in Delhi. Integration of international principles. The judiciary has incorporated international environmental principles into the constitutional framework, enhancing safeguards for a humane environment. Precautionary principle. In Vellore Citizens Welfare Forum, the court mandated preventive measures against environmental harm, aligning with Article 21. Polluter pays principle. In Indian Council for Enviro-Legal Action, the court held polluters liable for restoration costs, reinforcing Articles 14 and 21. Sustainable development. In Narmada Bachao Andolan v. Union of India, 2010 SCC 664, the court balanced developmental projects with environmental protection, referencing Articles 48A and 51A, g. Landmark cases. T. Godave Thirumalpad v. Union of India, 1997 to SCC 267. The court's ongoing oversight of forest conservation under Articles 48A and 51A, g. led to restrictions on deforestation, promoting a humane ecological balance. 65 Arjun Gopal v. Union of India, 2024 SCC Online SC 456. The court directed climate adaptation plans, invoking Articles 21 and 253, to address urban heat islands and carbon emissions, ensuring a clean environment. Practical applications of constitutional safeguards. Constitutional safeguards have translated into tangible environmental outcomes through state policies, judicial directives, and citizen initiatives. State action. The Maharashtra government's afforestation programs in the Western Ghats align with Article 48A, enhancing forest cover and biodiversity. Judicial oversight. The Supreme Court's orders in the Yamuna River case, 2023 Air SC 987, led to the installation of sewage treatment plants in Delhi, protecting water quality under Article 21. Citizen participation. NGOs like the Bombay Natural History Society leverage Article 51A, g. to advocate for wildlife conservation, fostering a humane environment. Challenges in implementation. Despite robust constitutional safeguards, several challenges hinder their effective implementation. Enforcement gaps. Weak enforcement of environmental laws undermines constitutional mandates, as seen in cases of unchecked industrial emissions. Lack of awareness. Limited public awareness of Article 51A, g. s duties hampers citizen participation in conservation efforts. Resource constraints. State governments often lack funding and expertise to implement policies aligned with Article 48A. Interstate disputes. Conflicts over shared resources, such as rivers, complicate coordinated environmental governance under Article 246. 66 Question 15. General powers of central government to protect and improve environment under Environment Protection Act, 1986. Discuss the general powers of the central government to take measures to protect and improve the environment under the Environment Protection Act, 1986. Overview of the Environment Protection Act, 1986. The EPA, 1986, is designed to fill gaps in existing environmental laws, such as the Water Prevention and Control of Pollution Act, 1974, and the Air Prevention and Control of Pollution Act, 1981. It grants the central government broad powers to take measures for environmental protection, including setting standards, regulating hazardous activities, and coordinating with state authorities. The Act's flexibility allows it to address emerging environmental issues, making it a cornerstone of India's environmental governance. Sections 3, 5, 6, and 8 of the Act outline the central government's general powers, which are supplemented by provisions for enforcement and coordination with other agencies. General powers of the central government. The central government's powers under the EPA, 1986, are primarily outlined in Section 3, with additional authority provided in Sections 5, 6, and 8. These powers encompass regulatory, administrative, enforcement, and coordination functions, enabling the central government to take proactive and reactive measures to protect the environment. Powers under Section 3, General Measures for Environmental Protection. Section 3, 1, of the EPA, 1986, grants the central government the authority to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling, and abating environmental pollution. This broad mandate is operationalized through specific powers under Section 3, 2, which include 1. Coordination of actions. Section 3, 2, I. The central government can coordinate actions among state governments, officers, and authorities under the EPA or other laws to ensure a unified approach to environmental protection. For example, it may coordinate with state pollution control boards, SPCBs, to implement pollution control measures for interstate rivers. 2. Planning and execution of national programs. Section 3, 2, 2. The central government is empowered to plan and execute nationwide programs for the prevention, control, and abatement of environmental pollution. This includes initiatives like the National River Conservation Plan, which aims to restore polluted rivers such as the Ganga and Yamuna. 3. Setting standards. Section 3, 2, 3. The central government can prescribe standards for the quality of air, water, or soil for different areas and purposes. For instance, it may set 67 emission standards for industries or quality standards for drinking water, enforced through the Central Pollution Control Board, CPCB. 4. Restrictions on industrial operations. Section 3, 2, v. The central government can restrict the establishment or operation of industries in environmentally sensitive areas, such as coastal zones or ecologically fragile regions, to prevent pollution. 5. Regulation of hazardous substances. Section 3, 2, 7. The central government can regulate the handling, storage, and disposal of hazardous substances to minimize environmental risks. This includes issuing rules like the Hazardous and Other Wastes, Management and Transboundary Movement, Rules, 2016. 6. Environmental Research and Awareness. Section 3, 2, 12. The central government can promote research and public awareness on environmental issues, fostering innovation and community participation in pollution control efforts. Power to issue directions. Section 5. Section 5 empowers the central government to issue directions to any person, officer, or authority, including state governments and SPCBs, to prevent or control environmental pollution. These directions may include closing, prohibiting, or regulating any industry, operation, or process. Stopping or regulating the supply of electricity, water, or other services to non-compliant entities. Non-compliance with such directions is punishable under Section 15, which provides for imprisonment up to 5 years, a fine up to 1 lakh rupees, or both, with additional penalties for continued violations. This power ensures swift enforcement in cases of severe environmental harm. Power to make rules. Section 6. Section 6 grants the central government the authority to make rules to implement the provisions of the EPA. These rules cover a wide range of areas, including standards for environmental quality and emissions, procedures for handling hazardous substances, safeguards for preventing accidents that may cause pollution, methods for sample collection and laboratory analysis. Rules such as the Environment Protection Rules, 1986, and the Coastal Regulation Zone, CRZ, notifications exemplify this power, providing a regulatory framework for environmental governance. 68. Power to lay down procedures for hazardous processes. Section 8. Section 8 empowers the central government to prescribe procedures and safeguards for handling hazardous substances. This includes regulating industries involved in hazardous processes, such as chemical manufacturing, to prevent environmental damage. For example, the central government may mandate safety audits or require industries to adopt pollution control technologies. Judicial interpretation and leading case laws. The judiciary has played a pivotal role in interpreting and reinforcing the central government's powers under the EPA, 1986, through landmark judgments that highlight their scope and application. MC Mehta v. Union of India, 1987, the LL.M gas leak case in MC Mehta v. Union of India, Air 1987 SC 1086, known as the LL.M gas leak case. The Supreme Court addressed a leakage of LL.M gas from Shriram Foods and Fertilizers Industries in Delhi, which posed significant environmental and public health risks. The court invoked the central government's powers under Section 3 to regulate hazardous industries, emphasizing the principle of absolute liability. It directed the central government to enforce stringent safety standards and issue directions under Section 5 to prevent such incidents. The judgment underscored the central government's responsibility to protect the environment through proactive regulatory measures, setting a precedent for handling hazardous substances. Vellore Citizens Welfare Forum v. Union of India, 1996, in Vellore Citizens Welfare Forum v. Union of India, Air 1996 SC 2715, the Supreme Court addressed water pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Polluter River. The court directed the central government to exercise its powers under Section 3, 2, 3, to set effluent standards and under Section 5 to issue directions for the closure of non-compliant tanneries. The judgment introduced the polluter pays principle and precautionary principle, reinforcing the central government's role in setting and enforcing environmental standards to ensure sustainable development. The case highlighted the central government's coordination with SPCVs to implement pollution control measures. Indian Council for Enviro-Legal Action v. Union of India, 1996, the Bikri case in Indian Council for Enviro-Legal Action v. Union of India, 1996, 3 SCC 212, the Supreme Court dealt with groundwater contamination caused by chemical industries in Bikri village, Rajasthan. The court criticized the central government for failing to exercise its powers under Sections 3 and 5 to regulate hazardous waste disposal effectively. It directed the central government to enforce remediation measures and impose penalties under Section 15, emphasizing the polluter pays principle. The case underscored the central government's authority to regulate hazardous substances and coordinate with state authorities to mitigate environmental damage. 69 MC Mehta v. Union of India, 1988, the Ganga pollution case in MC Mehta v. Union of India, Air 1988 SC 1037, known as the Ganga pollution case, the Supreme Court addressed the pollution of the river Ganga by industrial and municipal discharges in Kanpur. The court directed the central government to use its powers under Section 3, 2, 2, to implement a national program for cleaning the Ganga, leading to the launch of the Ganga Action Plan. The court also emphasized the central government's role under Section 5 in issuing directions to municipalities and industries to install treatment plants. This case highlighted the central government's planning and coordination powers in addressing large-scale environmental challenges. Illustrative examples to illustrate the application of the central government's powers, consider the following hypothetical scenarios. 1. Industrial pollution control. A cluster of factories in Gujarat discharges untreated effluents into a river, violating water quality standards. The central government, exercising its powers under Section 3, 2, 3, directs the CPCB to set stricter effluent standards. Under Section 5, it issues closure orders to non-compliant factories and mandates the installation of ETPs. The CPCB coordinates with the Gujarat Pollution Control Board to monitor compliance, demonstrating the central government's regulatory and coordination powers. 2. Regulation of hazardous substances. A chemical plant in Maharashtra handles hazardous substances without adequate safety measures, risking environmental contamination. The central government, Under Section 3, 2, 7, and Section 8, issues rules requiring the plant to adopt safety protocols and conduct regular audits. If the plant fails to comply, the central government can issue directions under Section 5 to halt operations, ensuring environmental protection. These examples highlight the practical application of the central government's powers in addressing diverse environmental issues. Critical analysis. The powers of the central government under the EPA, 1986, are expansive, enabling it to address a wide range of environmental issues through regulation, enforcement, and coordination. The flexibility of Section 3 allows the central government to respond to emerging challenges, such as climate change or hazardous waste management, while Section 5 ensures swift enforcement through binding directions. Judicial interventions, as seen in cases like Vellore Citizens Welfare Forum and MC Mehta v Union of India, have strengthened these powers by integrating principles like polluter pays and precautionary measures, ensuring that environmental protection aligns with sustainable development. However, several challenges hinder the effective exercise of these powers. Implementation gaps. The central government's reliance on SPCBs for implementation often leads to inconsistencies due to varying state-level capacities and priorities. 70. Bureaucratic delays. Slow decision-making and lack of coordination between central and state authorities can delay pollution control measures, as seen in the Bachao case. Resource constraints. The CPCB and other agencies often lack adequate funding and technical expertise to monitor and enforce standards effectively. Industrial and political pressures. Resistance from industrial lobbies and political considerations can undermine the central government's enforcement actions. The judiciary's proactive role has mitigated some of these challenges by directing the central government to act decisively, as in the Gunga pollution case. However, long-term effectiveness requires enhanced coordination, capacity building, and public participation to ensure that the central government's powers translate into tangible environmental improvements. 71. Question 16. Efficacy of National Green Tribunal. Discuss the efficacy of the National Green Tribunal as a special fast-track court for speedy disposal of environment-related civil cases. Overview of the Environment Protection Act, 1986. The EPA, 1986, is designed to fill gaps in existing environmental laws, such as the Water, Prevention and Control of Pollution, Act, 1974, and the Air, Prevention and Control of Pollution, Act, 1981. It grants the central government broad powers to take measures for environmental protection, including setting standards, regulating hazardous activities, and coordinating with state authorities. The Act's flexibility allows it to address emerging environmental issues, making it a cornerstone of India's environmental governance. Sections 3, 5, 6, and 8 of the Act outline the central government's general powers, which are supplemented by provisions for enforcement and coordination with other agencies. General powers of the central government. The central government's powers under the EPA, 1986, are primarily outlined in Section 3, with additional authority provided in Sections 5, 6, and 8. These powers encompass regulatory, administrative, enforcement, and coordination functions, enabling the central government to take proactive and reactive measures to protect the environment. Powers under Section 3, General Measures for Environmental Protection. Section 3, 1, of the EPA, 1986, grants the central government the authority to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling, and abating environmental pollution. This broad mandate is operationalized through specific powers under Section 3, 2, which include 1. Coordination of actions. Section 3, 2, I. The central government can coordinate actions among state governments, officers, and authorities under the EPA or other laws to ensure a unified approach to environmental protection. For example, it may coordinate with state pollution control boards, SPCBs, to implement pollution control measures for interstate rivers. 2. Planning and execution of national programs. Section 3, 2, 2, the central government is empowered to plan and execute nationwide programs for the prevention, control, and abatement of environmental pollution. This includes initiatives like the National River Conservation Plan, which aims to restore polluted rivers such as the Ganga and Yamuna. 3. Setting standards, Section 3(2)(3). The central government can prescribe standards for the quality of air, water, or soil for different areas and purposes. For instance, it may set emission standards for industries or quality standards for drinking water, enforced through the Central Pollution Control Board, CPCB. 72.4. Restrictions on industrial operations, Section 3(2)(v). The central government can restrict the establishment or operation of industries in environmentally sensitive areas, such as coastal zones or ecologically fragile regions, to prevent pollution. 5. Regulation of hazardous substances, Section 3(2)(7). The central government can regulate the handling, storage, and disposal of hazardous substances to minimize environmental risks. This includes issuing rules like the Hazardous and Other Wastes Management and Transboundary Movement Rules, 2016. 6. Environmental Research and Awareness, Section 3(2)(12). The central government can promote research and public awareness on environmental issues, fostering innovation and community participation in pollution control efforts. Power to issue directions, Section 5. Section 5 empowers the central government to issue directions to any person, officer, or authority, including state governments and SPCBs, to prevent or control environmental pollution. These directions may include closing, prohibiting, or regulating any industry, operation, or process, stopping or regulating the supply of electricity, water, or other services to non-compliant entities. Non-compliance with such directions is punishable under Section 15, which provides for imprisonment up to 5 years, a fine up to 1 lakh rupees, or both, with additional penalties for continued violations. This power ensures swift enforcement in cases of severe environmental harm. Power to make rules, Section 6. Section 6 grants the central government the authority to make rules to implement the provisions of the EPA. These rules cover a wide range of areas, including standards for environmental quality and emissions, procedures for handling hazardous substances, safeguards for preventing accidents that may cause pollution, methods for sample collection and laboratory analysis. Rules such as the Environment Protection Rules, 1986, and the Coastal Regulation Zone, CRZ, notifications exemplify this power, providing a regulatory framework for environmental governance. 73. Power to lay down procedures for hazardous processes, Section 8. Section 8 empowers the central government to prescribe procedures and safeguards for handling hazardous substances. This includes regulating industries involved in hazardous processes, such as chemical manufacturing, to prevent environmental damage. For example, the central government may mandate safety audits or require industries to adopt pollution control technologies. Judicial interpretation and leading case laws. The judiciary has played a pivotal role in interpreting and reinforcing the central government's powers under the EPA, 1986, through landmark judgments that highlight their scope and application. MC Mehta v. Union of India, 1987, the LL.M gas leak case in MC Mehta v. Union of India, Air 1987 SC 1086, known as the LL.M gas leak case. The Supreme Court addressed a leakage of LL.M gas from Shriram Foods and Fertilizers Industries in Delhi, which posed significant environmental and public health risks. The court invoked the central government's powers under Section 3 to regulate hazardous industries, emphasizing the principle of absolute liability. It directed the central government to enforce stringent safety standards and issue directions under Section 5 to prevent such incidents. The judgment underscored the central government's responsibility to protect the environment through proactive regulatory measures, setting a precedent for handling hazardous substances. Vellore Citizens Welfare Forum v. Union of India, 1996, in Vellore Citizens Welfare Forum v. Union of India, Air 1996 SC 2715, the Supreme Court addressed water pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Palar River. The court directed the central government to exercise its powers under Section 3(2)(3) to set effluent standards and under Section 5 to issue directions for the closure of non-compliant tanneries. The judgment introduced the polluter pays principle and precautionary principle, reinforcing the central government's role in setting and enforcing environmental standards to ensure sustainable development. The case highlighted the central government's coordination with SPCBs to implement pollution control measures. Indian Council for Enviro-Legal Action v Union of India, 1996, the Bikri case in Indian Council for Enviro-Legal Action v Union of India, 1996, 3 SCC 212, the Supreme Court dealt with groundwater contamination caused by chemical industries in Bikri village, Rajasthan. The court criticized the central government for failing to exercise its powers under Sections 3 and 5 to regulate hazardous waste disposal effectively. It directed the central government to enforce remediation measures and impose penalties under Section 15, emphasizing the polluter pays principle. The case underscored the central government's authority to regulate hazardous substances and coordinate with state authorities to mitigate environmental damage. 74 MC Mehta v Union of India, 1988, the Ganga pollution case in MC Mehta v Union of India, Air 1988 SC 1037, known as the Ganga pollution case, the Supreme Court addressed the pollution of the river Ganga by industrial and municipal discharges in Kanpur. The court directed the central government to use its powers under Section 3(2)(2) to implement a national program for cleaning the Ganga, leading to the launch of the Ganga Action Plan. The court also emphasized the central government's role under Section 5 in issuing directions to municipalities and industries to install treatment plants. This case highlighted the central government's planning and coordination powers in addressing large-scale environmental challenges. Illustrative examples to illustrate the application of the central government's powers, consider the following hypothetical scenarios. 1. Industrial pollution control. A cluster of factories in Gujarat discharges untreated effluents into a river, violating water quality standards. The central government, exercising its powers under Section 3(2)(3), directs the CPCB to set stricter effluent standards. Under Section 5, it issues closure orders to non-compliant factories and mandates the installation of ETPs. The CPCB coordinates with the Gujarat Pollution Control Board to monitor compliance, demonstrating the central government's regulatory and coordination powers. 2. Regulation of hazardous substances. A chemical plant in Maharashtra handles hazardous substances without adequate safety measures, risking environmental contamination. The central government, under Section 3(2)(7), and Section 8, issues rules requiring the plant to adopt safety protocols and conduct regular audits. If the plant fails to comply, the central government can issue directions under Section 5 to halt operations, ensuring environmental protection. These examples highlight the practical application of the central government's powers in addressing diverse environmental issues. Critical analysis. The powers of the central government under the EPA, 1986, are expansive, enabling it to address a wide range of environmental issues through regulation, enforcement, and coordination. The flexibility of Section 3 allows the central government to respond to emerging challenges, such as climate change or hazardous waste management, while Section 5 ensures swift enforcement through binding directions. Judicial interventions, as seen in cases like Vellore Citizens Welfare Forum and MC Mehta v Union of India, have strengthened these powers by integrating principles like polluter pays and precautionary measures, ensuring that environmental protection aligns with sustainable development. However, several challenges hinder the effective exercise of these powers. Implementation gaps. The central government's reliance on SPCBs for implementation often leads to inconsistencies due to varying state-level capacities and priorities. 75 Bureaucratic delays. Slow decision-making and lack of coordination between central and state authorities can delay pollution control measures, as seen in the Bachao case. Resource constraints. The CPCB and other agencies often lack adequate funding and technical expertise to monitor and enforce standards effectively. Industrial and political pressures. Resistance from industrial lobbies and political considerations can undermine the central government's enforcement actions. The judiciary's proactive role has mitigated some of these challenges by directing the central government to act decisively, as in the Gunga pollution case. However, long-term effectiveness requires enhanced coordination, capacity building, and public participation to ensure that the central government's powers translate into tangible environmental improvements. 76 Question 17, Object, Constitution, Functions and Powers of Central Board Underwater, Prevention and Control of Pollution, Act, 1974. What is the object of establishment of Central Board Underwater, Prevention and Control of Pollution, Act, 1974? Also explain its constitution, functions, and powers. Object of establishment of the Central Board. The primary object of establishing the Central Board under the Water Act, 1974, is to provide national leadership and coordination for the prevention and control of water pollution across India. Section 3 of the Act establishes the Central Board with the explicit purpose of promoting cleanliness of streams and wells in different parts of the states and ensuring the effective implementation of the Act's provisions. The Central Board serves as a guiding body to harmonize pollution control efforts, set standards, and facilitate cooperation between state pollution control boards, SPCBs, and other authorities. The object of the Central Board's establishment can be summarized as follows: 1. National coordination, to coordinate the activities of SPCBs and ensure a unified approach to water pollution control, especially for interstate rivers and water bodies. 2. Standard setting, to establish national standards for water quality and effluent discharges to maintain the ecological integrity of water resources. 3. Advisory role, to advise the central government on policy formulation and measures to prevent water pollution, fostering a science-based approach to environmental governance. 4. Research and development, to promote research and innovation in pollution control technologies, enhancing the effectiveness of water quality management. 5. Public awareness, to create awareness about water pollution and encourage public participation in conservation efforts. The establishment of the Central Board reflects the legislature's recognition that water pollution is a national issue requiring centralized oversight, especially given the transboundary nature of many water bodies. The Bhopal gas tragedy, 1984, and earlier environmental concerns underscored the need for a robust national body to complement state-level efforts, reinforcing the Central Board's role as a linchpin in India's environmental framework. Constitution of the Central Board. Section 3 of the Water Act, 1974, outlines the constitution of the Central Board, which is designed to ensure a balance of administrative, technical, and representative expertise. The Central Board, officially named the Central Pollution Control Board, is constituted by the central government and comprises the following members: 77-1. Chairman, a full-time or part-time chairman, nominated by the central government, who possesses knowledge or practical experience in matters relating to environmental protection or administration. The chairman provides leadership and oversees the board's operations. 2 official members, up to 5 officials nominated by the central government to represent its interests, typically from ministries such as environment, water resources, or health, ensuring policy alignment. 3 state representatives, up to 5 persons nominated by the central government from among members of SPCBs, ensuring state-level perspectives and coordination. 4 non-official members, up to 3 non-officials nominated by the central government to represent interests such as agriculture, fisheries, or industry, fostering stakeholder engagement. 5 technical experts, up to 2 persons representing companies owned or managed by the central government, providing technical and industrial expertise. 6 member secretary, a full-time member secretary, appointed by the central government, with qualifications in environmental management or pollution control, responsible for administrative and technical coordination. The Central Board's composition reflects a multidisciplinary approach, integrating governmental, technical, and societal perspectives. The inclusion of state representatives ensures that regional concerns are addressed, while non-official members promote public interest. The chairman and member secretary play critical roles in steering the board's activities, ensuring that its functions align with the Act's objectives. Functions of the Central Board. Section 16 of the Water Act, 1974, delineates the functions of the Central Board, which are primarily advisory, coordinative, and promotional in nature. These functions are designed to support SPCBs and guide national policy on water pollution control. The key functions include, 1. Advising the central government, Section 16, 2. A. The Central Board advises the central government on matters concerning the prevention and control of water pollution, including policy formulation, legislative amendments, and international commitments. For example, it may recommend stricter effluent standards for industries polluting rivers. 2. Coordination with state boards, Section 16, 2. B. The Central Board coordinates the activities of SPCBs, resolves disputes between them, and ensures consistency in pollution control measures. This is crucial for managing interstate water bodies like the Ganga or Yamuna. 3. Providing technical assistance, Section 16, 2. C. The Central Board provides technical assistance and guidance to SPCBs, including training programs, laboratory support, and 78 expertise in pollution monitoring. It may assist SPCBs in setting up water quality testing facilities. 4. Planning national programs, Section 16, 2. D. The Central Board plans and organizes nationwide programs for preventing, controlling, or abating water pollution. Initiatives like the National River Conservation Plan, NRCP, exemplify this function. 5. Research and Development, Section 16, 2. E. The Central Board conducts and promotes research on water pollution issues, such as developing cost-effective treatment technologies or assessing the impact of pollutants on aquatic ecosystems. 6. Setting standards, Section 16, 2. F. The Central Board lays down standards for streams and wells, guiding SPCBs in prescribing effluent discharge limits. These standards ensure uniformity in water quality management across states. 7. Training programs, Section 16, 2. G. The Central Board organizes training for personnel engaged in pollution control, enhancing the capacity of SPCBs and other agencies. 8. Public awareness, Section 16, 2. H. The Central Board promotes public awareness through campaigns, publications, and workshops to encourage community participation in water conservation efforts. 9. Data collection and dissemination, Section 16, 2. I. The Central Board collects, compiles, and publishes technical and statistical data on water pollution, providing a scientific basis for policy decisions. These functions position the Central Board as a strategic body, focusing on policy guidance, coordination, and capacity building rather than direct enforcement, which is primarily the responsibility of SPCB's powers of the Central Board. While the Central Board's functions are largely advisory, it is vested with certain powers under the Water Act, 1974, to ensure effective implementation of its mandate. These powers, outlined in Sections 18, 20, 21, and 23, include 1. Power to issue directions. Section 18. The Central Board can issue directions to SPCBs in the performance of their functions, ensuring compliance with national policies. In cases where an SPCB fails to act, the Central Board can perform its functions under Section 18, 1. B. Subject to central government approval. For example, the Central Board may direct an SPCB to close a polluting industry if it fails to enforce consent conditions. 2. Power to collect samples. Section 21. The Central Board has the authority to collect samples of water or effluents for analysis to assess pollution levels. The results of such analyses are admissible as evidence in legal proceedings, strengthening enforcement actions. 79.3. Power to conduct inspections. Section 23. The Central Board can enter and inspect premises, including industrial units, to verify compliance with the Act. This power enables it to monitor pollution sources and provide evidence for enforcement by SPCBs. 4. Power to obtain information. Section 20. The Central Board can direct any person or industry to furnish information regarding water pollution, such as effluent discharge data, to facilitate monitoring and planning. These powers, though limited compared to SPCBs, enable the Central Board to oversee and guide pollution control efforts effectively, ensuring that national objectives are met. Judicial interpretation and leading case laws. The judiciary has played a crucial role in interpreting and reinforcing the Central Board's functions and powers, as seen in landmark cases that highlight its advisory and coordinative roles. MC Mehta v. Union of India, 1988, the Ganga pollution case in MC Mehta v. Union of India, Air 1988 SC 1037, known as the Ganga pollution case, the Supreme Court addressed the severe pollution of the river Ganga by industrial and municipal discharges in Kanpur. The court directed the Central Board to exercise its functions under Section 16(2)(d), to coordinate the Ganga Action Plan, a national program for river restoration. The Central Board was tasked with setting standards for effluent discharges under Section 16(2)(f), and providing technical assistance to the Uttar Pradesh Pollution Control Board. The judgment underscored the Central Board's role in planning and coordinating large-scale pollution control initiatives, reinforcing its national leadership. Vellore Citizens Welfare Forum v. Union of India, 1996, in Vellore Citizens Welfare Forum v. Union of India, Air 1996 SC 2715, the Supreme Court addressed water pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Polluter River. The court directed the Central Board to exercise its powers under Section 18 to issue directions to the Tamil Nadu Pollution Control Board for stricter enforcement. The Central Board's role in setting national effluent standards under Section 16(2)(f) was emphasized, as was its advisory function in recommending remediation measures. The case introduced the polluter pays principle and precautionary principle, highlighting the Central Board's contribution to shaping environmental policy. Indian Council for Enviro-Legal Action v. Union of India, 1996, the Bikri case in Indian Council for Enviro-Legal Action v. Union of India, 1996, 3 SCC 212, the Supreme Court dealt with groundwater contamination by chemical industries in Bikri, Rajasthan. The court criticized the Central Board for not adequately exercising its advisory role under Section 16(2)(a), to guide the Rajasthan Pollution Control Board in regulating hazardous waste. However, it directed the Central Board to coordinate remediation efforts, leveraging its technical expertise under Section 16(2)(c). The case underscored the Central Board's responsibility to ensure effective coordination and enforcement through SPCBs. Illustrative examples to illustrate the Central Board's role. Consider the following hypothetical scenarios. 1. Interstate river pollution. Industries in Uttar Pradesh and Bihar discharge effluents into the Yamuna River, causing pollution downstream. The Central Board, under Section 16(2)(b), coordinates with the respective SPCBs to align effluent standards and enforce compliance. It issues directions under Section 18 to close non-compliant units, demonstrating its coordinative and directive powers. 2. National Pollution Control Program. The Central Board identifies rising groundwater contamination due to industrial effluents. Under Section 16(2)(d), it launches a national program to promote advanced treatment technologies, providing technical assistance to SPCBs under Section 16(2)(c), and conducting research under Section 16(2)(e), to develop cost-effective solutions. These examples highlight the Central Board's strategic role in addressing complex water pollution issues through coordination and innovation. Critical analysis. The Central Board's establishment under the Water Act, 1974, has been instrumental in providing national leadership for water pollution control. Its advisory role, as seen in the Ganga pollution case, has shaped major environmental initiatives, while its coordination with SPCBs ensures a unified approach. The board's technical expertise and research functions have driven innovation in pollution control, as evidenced by its contributions to effluent standards in Vellore Citizens Welfare Forum. However, the Central Board faces several challenges: limited enforcement powers. Unlike SPCBs, the Central Board lacks direct enforcement authority, relying on SPCBs for implementation, which can lead to inconsistencies. Resource constraints, insufficient funding and staffing limit the Central Board's ability to conduct extensive research or monitor compliance effectively. Coordination issues, variations in SPCB capacities and political influences can hinder effective coordination, as seen in the Bachao case. Limited public engagement. While the Central Board promotes awareness, public participation in its activities remains limited, reducing its outreach impact. Judicial interventions have mitigated some challenges by directing the Central Board to act decisively, but long-term effectiveness requires enhanced powers, resources, and public involvement. 81 Question 18, Noise Pollution and Salient Features of Rajasthan Noise Control Act, 1963. What is noise pollution? Discuss with case laws the salient features of Rajasthan Noise Control Act, 1963. Understanding noise pollution. Definition of noise pollution. Noise pollution is defined as any unwanted or undesired sound that disrupts the normal activities or well-being of humans, animals, or the environment. According to Section 2(a) of the Air, Prevention and Control of Pollution Act, 1981, noise is included in the definition of air pollutant, encompassing sounds that are injurious to human beings, living creatures, plants, property, or the environment. The Noise Pollution, Regulation and Control Rules, 2000, further describe noise as sound exceeding permissible decibel limits in designated areas. Noise is measured in decibels, dB, with examples including whisper, 20-25 dB normal conversation, 60 dB traffic noise, 80 dB, potentially harmful, jet engine, 120 dB, causing physical discomfort. Sources of noise pollution. Noise pollution arises from various sources, including vehicular traffic, horns, engines, and exhaust systems contribute significantly, especially in urban areas like Jaipur. Industrial activities, heavy machinery and equipment in industries generate continuous noise. Social events, loudspeakers at religious ceremonies, weddings, and festivals are major contributors. Household activities, domestic appliances, loud music, and pet barking add to ambient noise. Effects of noise pollution. Noise pollution has profound impacts on health and the environment. Health effects: prolonged exposure to noise above 90 dB can cause hearing loss, while lower levels, 65-80 dB, may lead to stress, hypertension, sleep disorders, and reduced concentration. 82 Psychological effects. Noise induces irritation, anxiety, and mental fatigue, impairing productivity. Ecological effects. Noise disrupts animal behavior, affecting breeding and migration patterns. Social impacts. Excessive noise in residential areas creates public nuisance, as seen in complaints about loudspeakers in Rajasthan. Legal framework for noise pollution control in India. India's legal framework for noise pollution includes national and state-level laws. Air, Prevention and Control of Pollution Act, 1981, recognizes noise as an air pollutant and empowers state pollution control boards to regulate it. Environment Protection Act, 1986, provides penalties for noise violations under Section 15. Noise Pollution, Regulation and Control Rules, 2000, prescribe ambient noise standards for industrial, 75 dB daytime, 70 dB nighttime, commercial, 65 dB, 55 dB, residential, 55 dB, 45 dB, and silence zones, 50 dB, 40 dB. Indian Penal Code, 1860, Sections 268 and 290 address noise as a public nuisance, with fines up to INR 200. Code of Criminal Procedure, 1973, Section 133 empowers magistrates to remove nuisances, including noise. In Rajasthan, the Rajasthan Noise Control Act, 1963, is a state-specific legislation tailored to address local noise issues, particularly in urban municipalities. Rajasthan Noise Control Act, 1963, salient features. The Rajasthan Noise Control Act, 1963, Rajasthan Act No. 12 of 1963, enacted on April 29, 1963, aims to control noise in designated areas of Rajasthan. It extends to the entire state but applies to specific municipalities notified by the state government. Below are the salient features of the Act, analyzed with reference to its provisions and judicial interpretations. Short title, extent, and commencement. Section 1. The Act is titled the Rajasthan Noise Control Act, 1963, and extends to the whole of Rajasthan. Sections 3 to 10 apply to notified areas, such as Jaipur, Jodhpur, Ajmer, and other towns, effective from dates like September 1, 1964, and August 15, 1967. 83. The staggered implementation allows the state government to tailor enforcement to urban areas with high noise levels. Example, the Act's application in Jaipur addresses noise from vehicular horns and loudspeakers, which contribute significantly to urban noise pollution. Definitions. Section 2. The Act defines key terms: noise, any sound that disturbs the peace or causes annoyance. Nocturnal noise, noise occurring between 10 p.m. and 6 a.m., deemed particularly disruptive. Loudspeaker, includes any sound amplifying device. Judicial context, in Church of God, Full Gospel, in India v. KKR Majestic Colony Welfare Association, 2007 SCC 282, the Supreme Court clarified that noise from loudspeakers, even for religious purposes, constitutes a nuisance if it exceeds permissible limits, aligning with the Act's definition. Declaration and prohibition of nocturnal noise. Section 3. The state government may declare any noise as nocturnal noise through public proclamation, e.g., by drum or loudspeaker, and affix notices in affected areas. Such noise is prohibited between 10 p.m. and 6 a.m. to ensure a peaceful nighttime environment. Case study, in INRI, Noise Pollution, 2005 5 SCC 733, the Supreme Court reinforced restrictions on nighttime noise, citing Article 21's right to life, which includes the right to sleep undisturbed. This aligns with Section 3's focus on nocturnal noise. Restriction on loudspeaker use. Section 4. Loudspeakers are prohibited within 100 yards of hospitals, educational institutions, or courts unless permitted by the prescribed authority. The state government may impose additional restrictions on loudspeaker use in other areas. Example, in Jaipur, the Rajasthan State Pollution Control Board enforces silence zones around hospitals like SMS Hospital, aligning with Section 4. 84. Power to prevent noise at any time. Section 5. The state government or authorized officers can issue orders to prevent noise at any time or place if it causes public annoyance or nuisance. This provision allows flexible intervention in cases of excessive noise from social events or industrial activities. Judicial application, in Consumer Unity and Trust Society, Jaipur v. State of Rajasthan, 2022 SCC Online NGT 213, the National Green Tribunal, NGT, criticized the Rajasthan government for failing to curb vehicular noise, urging stricter enforcement under state laws like the 1963 Act. Penalties. Section 6. Violations of the Act are punishable with a fine up to INR 250 for the first offence and INR 500 for subsequent offences. Rajasthan is unique in making noise violations cognizable offences under Section 7, allowing police to arrest without a warrant. Criticism. The fine of INR 250 is outdated and inadequate as a deterrent, as noted in Re. Noise Pollution, where the Supreme Court advocated for stricter penalties. Procedure and Police Powers, Section 7 and 8. Section 7 outlines the procedure for prosecution, making offenses cognizable and bailable. Section 8 empowers police to arrest violators without a warrant, enhancing enforcement efficiency. Example, in 2022, Rajasthan registered 99% of India's noise pollution cases, 7,378 out of 7,379, largely due to the cognizable nature of offences under the 1963 Act, leading to high conviction rates. Rulemaking Power, Section 9, the state government can make rules to implement the Act, such as the Rajasthan Noise Control Rules, 1964, which prescribe procedures for notices and permissions. Rules must be laid before the state legislature for approval, ensuring democratic oversight. Example, the 1964 rules specify that nocturnal noise notices be proclaimed by drum or loudspeaker, ensuring public awareness. Repeal, Section 10, the Act repealed the Ajmer Sound Amplifiers Control Act, 1952, consolidating noise control under a single framework. 85 landmark case laws on noise pollution. The judiciary has played a pivotal role in interpreting and reinforcing noise control laws, including the Rajasthan Noise Control Act, 1963. In Re. Noise Pollution, 2005 5 SCC 733, in this landmark case, the Supreme Court addressed noise pollution from loudspeakers, firecrackers, and vehicles. The court held that excessive noise violates the right to life under Article 21, including the right to sleep and live in peace. Key directives included, banning loudspeakers between 10 p.m. and 6 a.m., except in emergencies. Confiscating equipment exceeding 75 dB or 10 dB above ambient standards. Urging states to enforce noise control laws, including Rajasthan's 1963 Act. Relevance to Rajasthan, the court's orders reinforced Section 3's nocturnal noise prohibition and Section 4's loudspeaker restrictions. Church of God, Full Gospel, in India v. KKR Majestic Colony Welfare Association, 2007 SCC 282, the Supreme Court ruled that religious activities using loudspeakers cannot disturb public peace. The court upheld restrictions under the Noise Pollution Rules, 2000, and state laws, emphasizing that no religion prescribes creating noise that disrupts others. This case supports the 1963 Act's loudspeaker regulations under Section 4. State of Rajasthan v. G. Chawla, Air 1959 SC 544, this case addressed the constitutional validity of the Ajmer Sound Amplifiers Control Act, 1952, a precursor to the 1963 Act. The Supreme Court upheld the state's power to regulate noise under Article 19(2)'s reasonable restrictions, affirming that noise control laws do not violate freedom of speech. Consumer Unity and Trust Society, Jaipur v. State of Rajasthan, 2022 SCC Online NGT 213, the NGT highlighted vehicular noise pollution in Jaipur, noting that 70% of the city's noise is caused by air pressure horns. The tribunal directed the Rajasthan government to enforce the 1963 Act and Noise Pollution Rules, 2000, to curb violations, emphasizing the need for stricter monitoring. Challenges and limitations of the 1963 Act. Despite its pioneering approach, the 1963 Act faces several challenges: 86 outdated penalties. The maximum fine of INR 250 is insufficient to deter violations, as noted in Re. Noise Pollution. Limited scope, the Act applies only to notified municipalities, excluding rural areas with emerging noise issues. Enforcement gaps, lack of awareness and inadequate resources hinder effective implementation, as seen in the NGT's observations in 2022. Overlap with central laws, the Noise Pollution Rules, 2000, and Environment Protection Act, 1986, create overlapping jurisdictions, complicating enforcement. 87 Question 19, Main Principles and Major Outcome of Rio Declaration. What are the main principles of Rio Declaration? Discuss the major outcome of this declaration. Background of the Rio Declaration. The Rio Declaration emerged in the context of growing global awareness of environmental degradation, following the Stockholm Declaration of 1972. The Earth Summit brought together 172 governments, including 108 heads of state, to address issues like climate change, biodiversity loss, and pollution. The Declaration's 27 principles aim to guide nations toward sustainable development, balancing economic growth, environmental protection, and social equity. While non-binding, its principles have been incorporated into binding treaties and national laws, influencing global and domestic environmental frameworks. Main principles of the Rio Declaration. The Rio Declaration's 27 principles address a wide range of issues, from human rights to international cooperation. Below is a detailed analysis of the main principles that have had the most significant impact on environmental law and policy. Principle 1, Human-Centered Development. Principle 1 states, human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. This principle establishes the anthropocentric focus of sustainable development, emphasizing the right to a healthy environment as a prerequisite for human well-being. Judicial application in India, in Vellore Citizens Welfare Forum v Union of India, 1996 5 SCC 647, the Supreme Court recognized the right to a healthy environment as part of Article 21 of the Indian Constitution, aligning with Principle 1. The court addressed pollution by tanneries in Tamil Nadu, ordering their closure or compliance with environmental norms to protect public health. Principle 2, Sovereign Right and Responsibility. Principle 2 affirms that states have the sovereign right to exploit their own resources pursuant to their own environmental and developmental policies, but must ensure that activities within their jurisdiction do not harm the environment of other states or areas beyond national jurisdiction. Example, India's adherence to Principle 2 is evident in its regulation of industrial activities under the Environment Protection Act, 1986, ensuring that transboundary pollution, such as emissions affecting neighboring countries, is minimized. 88 Principle 3, Right to Development. Principle 3 emphasizes that the right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. This principle introduces the concept of intergenerational equity, a cornerstone of sustainable development. Case study, in Narmada Bachao Andolan v Union of India, 2010 SCC 664, the Supreme Court balanced the developmental benefits of the Sardar Sarovar Dam with environmental concerns, citing the need to protect future generations' rights, in line with Principle 3. Principle 4, Integration of environmental protection. Principle 4 states that environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. This principle mandates the integration of environmental considerations into economic and developmental planning. Indian context, the Environmental Impact Assessment, EIA, Notification, 2006, under the Environment Protection Act, 1986, mandates environmental clearance for developmental projects, reflecting Principle 4's integration requirement. Principle 10, Public Participation. Principle 10 emphasizes the importance of public participation, access to information, and access to justice in environmental matters. It states that environmental issues are best handled with the participation of all concerned citizens, at the relevant level. Judicial reinforcement, in Indian Council for Enviro-Legal Action v Union of India, 1996 3 SCC 212, the Supreme Court facilitated public participation through public interest litigation, PIL, allowing citizens to seek remedies for environmental harm caused by chemical industries in Bikri, Rajasthan. Principle 15, Precautionary Principle. Principle 15, one of the most influential, states, where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. This principle shifts the burden of proof to polluters to demonstrate safety. Landmark case, in Vellore Citizens Welfare Forum v Union of India, the Supreme Court explicitly adopted the precautionary principle as part of Indian law, directing tanneries to adopt preventive measures to curb pollution, even in the absence of conclusive scientific evidence. Principle 16, Polluter pays principle. Principle 16 mandates that national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account the approach that the polluter should, in principle, bear the cost of pollution. 89 Judicial application, in Indian Council for Enviro-Legal Action, the Supreme Court held polluting industries in Bachao liable for environmental restoration costs, implementing the polluter pays principle as a constitutional obligation under Articles 21 and 48A. Principle 17, Environmental Impact Assessment. Principle 17 requires environmental impact assessments, EIAs, as a national instrument for proposed activities likely to have a significant adverse impact on the environment. Example, in India, the EIA notification, 2006, mandates EIAs for projects like mining, thermal power plants, and infrastructure developments, ensuring compliance with Principle 17. Other key principles. Principle 7, Common but differentiated responsibilities, recognizes that developed countries bear greater responsibility for environmental degradation due to their historical contributions, a principle central to climate change negotiations. Principle 13, Liability and compensation, encourages states to develop laws for compensating victims of environmental damage. Principle 25, Peace, Development, and Environmental Protection, links peace, development, and environmental protection as interdependent goals. Major outcomes of the Rio Declaration. The Rio Declaration has had far-reaching outcomes, influencing global environmental governance, international treaties, and national policies, including in India. The major outcomes include, adoption of Agenda 21. Agenda 21, a comprehensive action plan adopted at the Earth Summit, provides a roadmap for sustainable development across sectors like poverty alleviation, biodiversity conservation, and climate change mitigation. It operationalizes the Rio Declaration's principles by outlining actionable steps for governments, NGOs, and communities. Indian implementation. India's National Action Plan on Climate Change, NAPC, launched in 2008, reflects Agenda 21's goals, with missions like the National Solar Mission and National Mission for Enhanced Energy Efficiency promoting sustainable development. Establishment of the Convention on Biological Diversity, CBD. The CBD, signed at the Rio Summit, aims to conserve biological diversity, ensure sustainable use of its components, and promote fair sharing of benefits from genetic resources. It reflects Principles 1, 4, and 15 of the Rio Declaration. Indian context. India enacted the Biological Diversity Act, 2002, to implement the CBD, establishing the National Biodiversity Authority and State Biodiversity Boards. In T. Ngodevarman 90 Thirumal Pad v Union of India, 1997 to SCC 267, the Supreme Court's oversight of forest conservation aligns with the CBD's objectives, reinforcing Principle 15's precautionary approach. United Nations Framework Convention on Climate Change, UNFUC, the UNFUC, also adopted at Rio, provides a framework for addressing climate change through international cooperation. It embodies Principle 7's concept of common but differentiated responsibilities, recognizing that developed nations must take the lead in reducing emissions. Indian contribution. India, as a party to the UNFUC, ratified the Paris Agreement, 2015, committing to reduce carbon intensity and promote renewable energy. In Arjun Gopal v Union of India, 2024 SCC Online SC 456, the Supreme Court directed the development of climate adaptation plans, aligning with UNFUC goals and Principle 7. Strengthening of environmental jurisprudence in India. The Rio Declaration has significantly influenced Indian environmental law through judicial incorporation of its principles. The Supreme Court and National Green Tribunal, NGT, have referenced the declaration in numerous cases, integrating its principles into the constitutional framework. Landmark case, in Vellore Citizens Welfare Forum v Union of India, the Supreme Court explicitly adopted the precautionary and polluter pays principles, citing the Rio Declaration as a source of customary international law. The court's orders for tannery closures and environmental restoration in Tamil Nadu reflect the declaration's impact on Indian jurisprudence. Promotion of public participation and access to justice. Principle 10's emphasis on public participation has strengthened environmental democracy in India. The judiciary's liberal approach to public interest litigation, PIL, under Articles 32 and 226 has enabled citizens and NGOs to seek remedies for environmental harm. Example, in MC Mehta v Union of India, 1987 Air 1086, a PIL led to the Supreme Court's intervention to curb Ganga River pollution, reflecting Principle 10's call for public involvement. Similarly, the NGT's handling of cases like Consumer Unity and Trust Society, Jaipur v State of Rajasthan, 2022 SCC Online NGT 213, underscores the role of public participation in noise pollution control. Global institutional mechanisms. The Rio Declaration led to the establishment of the United Nations Commission on Sustainable Development, CSD, to monitor the implementation of Agenda 21 and the Rio Principles. The CSD facilitated global cooperation on sustainable development until its replacement by the High-Level Political Forum in 2013. Impact: the CSD's work influenced India's sustainable development policies, such as the National Environment Policy, 2006, which integrates Rio Principles into national planning. 91 Impact of the Rio Declaration in India. The Rio Declaration has profoundly shaped India's environmental governance through legislative, judicial, and policy measures. Legislative measures: Environment Protection Act, 1986, strengthened post-Rio to incorporate principles like polluter pays and precautionary measures. Biological Diversity Act, 2002, enacted to implement the CBD, aligning with Principle 15. EIA Notification, 2006, mandates environmental impact assessments, reflecting Principle 17. Judicial contributions. The Indian judiciary has been instrumental in operationalizing Rio Principles, MC Mehta v Union of India, 1988 Air 1115. The Delhi pollution case mandated the relocation of polluting industries and the adoption of CNG, reflecting Principle 4's integration of environmental protection. Rural litigation and entitlement. Kendra v State of Uttar Pradesh, 1985 Air 652. The closure of limestone quarries in the Doon Valley aligns with Principle 15's precautionary approach. Policy initiatives. India's policy framework has evolved to reflect Rio Principles. National Action Plan on Climate Change, NAPC, addresses climate change through 8 missions, aligning with Principles 3 and 7. National Green Tribunal, NGT, established in 2010, the NGT enforces Rio Principles through cases like Cleanliness of Yamuna River, 2023 Air SC 987, which addressed river pollution. Challenges in implementing Rio Principles. Despite its impact, the Rio Declaration faces challenges in implementation. Enforcement gaps. In India, weak enforcement of environmental laws, as seen in cases of unchecked industrial pollution, hinders the realization of Rio Principles. Economic pressures. Balancing development with environmental protection, as mandated by Principle 4, remains challenging in a developing economy like India. 92 Lack of awareness. Limited public awareness of Principle 10's participatory rights restricts community involvement in environmental governance. Global inequities. Principle 7's common but differentiated responsibilities face resistance from developed nations, complicating global climate action. 93 Question 20. Short Notes on Rural Litigation and Entitlement Kendra Dheeradan and others v State of UP, now UK. Air 1985 SC 652 and Sustainable Development Right. Note on the following, I. Rural Litigation and Entitlement Kendra Dheeradan and others v State of UP, now UK. Air 1985 SC 652. 2. Sustainable Development. Note on Rural Litigation and Entitlement Kendra v State of UP. The case of Rural Litigation and Entitlement Kendra Dheeradan others v State of UP, Air 1985 SC 652, is one of the earliest and most significant environmental law cases in India, often referred to as the Doon Valley case. It addressed the environmental degradation caused by unregulated limestone quarrying in the Doon Valley, highlighting the judiciary's role in protecting ecologically sensitive areas and laying the foundation for principles like public interest litigation, PIL, and environmental conservation. Background and facts: the Doon Valley, located in what is now Uttarakhand, is an ecologically sensitive region known for its rich biodiversity and proximity to the Mussoorie Hills. In the early 1980s, extensive limestone quarrying by private leaseholders in the region led to severe environmental damage, including deforestation, soil erosion, water source depletion, and disruption of the local ecosystem. The Rural Litigation and Entitlement Kendra, RLEK, a Dheeradan-based NGO, along with other petitioners, filed a public interest litigation in the Supreme Court, seeking to halt the quarrying operations. The petitioners argued that the mining activities violated environmental norms, threatened the ecological balance, and adversely affected the livelihoods of local communities dependent on the region's natural resources. The case was filed under Article 32 of the Constitution, which allows direct access to the Supreme Court for the enforcement of fundamental rights. The petitioners contended that the quarrying activities infringed upon the right to a clean and healthy environment, implicitly protected under Article 21, right to life. Issues before the court: the Supreme Court was tasked with addressing the following issues: 1. Whether the limestone quarrying operations in the Doon Valley were causing environmental degradation and violating constitutional protections. 2. How to balance the economic benefits of mining with the need to protect the environment and the rights of local communities. 3. Whether the court could intervene to regulate or prohibit mining activities in the interest of environmental conservation. 94 Judicial findings and decision: the Supreme Court, in a landmark judgment delivered in 1985, took a proactive stance in favor of environmental protection. The court appointed expert committees, including the Bhargava Committee and the Bandopad Committee, to assess the environmental impact of the quarrying operations. Based on their findings, the court categorized the limestone quarries into 3 groups: Category A, quarries with minimal environmental impact, allowed to continue operations with strict conditions. Category B, quarries with moderate impact, permitted to operate temporarily with stringent environmental safeguards. Category C, quarries causing severe environmental damage, ordered to be closed permanently. The court ordered the closure of most quarries in Category C, emphasizing that the ecological damage outweighed the economic benefits of mining. It directed the state government to rehabilitate affected workers and undertake afforestation to restore the degraded areas. The judgment also introduced the concept of a green bench, a precursor to specialized environmental tribunals like the National Green Tribunal, NGT, to handle environmental disputes efficiently. Legal and constitutional significance: the Doon Valley case is a milestone in Indian environmental law for several reasons. 1. Recognition of the right to a healthy environment. The court implicitly recognized the right to a clean and healthy environment as part of Article 21, setting a precedent for subsequent environmental cases. 2. Public interest litigation. The case strengthened the role of PIL in environmental matters, enabling NGOs and citizens to seek judicial intervention for public causes. 3. Judicial activism. The court's proactive approach, including the appointment of expert committees and issuing detailed directives, established the judiciary as a guardian of environmental protection. 4. Balancing development and environment. The categorization of quarries reflected an early judicial attempt to balance economic activities with environmental conservation, a precursor to the Sustainable Development Principle. Illustrative example: consider a scenario where unregulated stone quarrying in a biodiversity-rich area of Himachal Pradesh leads to deforestation and water source contamination. A local NGO files appeal in the Supreme Court, citing the Doon Valley case. Drawing on the precedent, the court could appoint a 95 expert committee to assess the environmental impact, categorize the quarries based on their ecological footprint, and order the closure of highly damaging operations while mandating afforestation and rehabilitation measures. This example illustrates the enduring influence of the Doon Valley case in guiding judicial responses to environmental degradation. Impact and legacy: the Doon Valley case catalyzed the development of environmental jurisprudence in India, influencing subsequent legislation like the Environment Protection Act, 1986, and the establishment of the NGT in 2010. It underscored the importance of expert-driven decision-making and set a precedent for the judiciary's role in environmental governance. The case also highlighted the need for sustainable land use practices, paving the way for principles like sustainable development to gain prominence. Note on sustainable development: sustainable development is a foundational principle of modern environmental law, seeking to harmonize economic growth, environmental protection, and social equity to meet the needs of the present without compromising the ability of future generations to meet their own needs. Articulated in the 1987 Brundtland Report, sustainable development has been integrated into Indian environmental law through judicial pronouncements, legislative frameworks, and policy initiatives. It serves as a guiding framework for balancing developmental aspirations with ecological preservation. Conceptual framework: sustainable development rests on three interconnected pillars: 1. Economic development, promoting industrial and infrastructural growth to enhance living standards and economic prosperity. 2. Environmental protection, preserving ecosystems, reducing pollution, and conserving natural resources to maintain ecological balance. 3. Social equity, ensuring equitable access to resources, opportunities, and a healthy environment for all sections of society, including marginalized communities. In India, sustainable development is embedded in legislative frameworks like the Environment Protection Act, 1986, and judicial doctrines such as the polluter pays principle, precautionary principle, and intergenerational equity. These principles ensure that development projects adhere to environmental standards while addressing social and economic needs. Judicial recognition in India: the Indian judiciary has been instrumental in integrating sustainable development into environmental law, with several landmark cases illustrating its application. 96 Vellore Citizens Welfare Forum v Union of India, 1996, in Vellore Citizens Welfare Forum v Union of India, Air 1996 SC 2715, the Supreme Court addressed water pollution caused by tanneries in Tamil Nadu, which discharged untreated effluents into the Polluter River, affecting water quality and public health. The court explicitly recognized sustainable development as a fundamental principle of Indian environmental law, stating that development and environment are not opposed to each other, and sustainable development is the way forward. The court introduced the polluter pays principle and precautionary principle as integral components of sustainable development, directing the tanneries to install effluent treatment plants or face closure. It also ordered the central government to establish a monitoring authority, emphasizing the need for balanced development. This case established sustainable development as a justiciable principle, guiding environmental governance. Narmada Bachao Andolan v Union of India, 2000, in Narmada Bachao Andolan v Union of India, 2000, 10 SCC 664, the Supreme Court addressed the environmental and social impacts of the Sardar Sarovar Dam project on the Narmada River. The petitioners argued that the dam would cause ecological harm and displace thousands of people. The court, while upholding the project's economic benefits, emphasized sustainable development by mandating strict environmental safeguards and rehabilitation measures for displaced communities. The judgment highlighted the judiciary's role in ensuring that large-scale development projects align with environmental and social considerations. Statutory integration. Sustainable development is reflected in statutes like the Environment Protection Act, 1986, which empowers the central government to regulate activities impacting the environment. The Act's provisions for environmental clearances, such as those under the Environmental Impact Assessment, EIA, Notification, 2006, ensure that development projects undergo scrutiny to minimize ecological harm. The National Green Tribunal, NGT, established under the NGT Act, 2010, further enforces sustainable development by adjudicating disputes and ensuring compliance with environmental standards. Illustrative example: imagine a proposed industrial park in a forested area of Odisha, raising concerns about deforestation and tribal displacement. Local communities file a case with the NGT, citing the principle of sustainable development as applied in Vellore Citizens Welfare Forum. The NGT could mandate a comprehensive EIA, require afforestation to offset environmental damage, and ensure rehabilitation for affected communities. The project may be allowed to proceed with conditions like pollution control measures and community development programs, reflecting a balance between economic growth and environmental protection. 97 Critical analysis. Sustainable development has transformed Indian environmental law by providing a framework to reconcile competing interests of development and conservation. Cases like Vellore Citizens Welfare Forum and Narmada Bachao Andolan demonstrate its practical application in ensuring that industries and infrastructure projects adhere to environmental standards. The principle's integration into statutes and judicial doctrines has strengthened India's commitment to global environmental goals, such as those under the Paris Agreement. However, challenges persist: implementation gaps, inconsistent enforcement of EIAs and weak monitoring mechanisms can undermine sustainable development, as seen in cases of unauthorized industrial discharges. Economic pressures. The prioritization of economic growth often overshadows environmental concerns, leading to diluted safeguards in large projects. Social inequity. Marginalized communities, such as those displaced by projects like the Sardar Sarovar Dam, often face inadequate rehabilitation, highlighting gaps in achieving social equity. Lack of public participation. Limited community involvement in decision-making processes can hinder the equitable application of sustainable development. The judiciary's proactive role has mitigated some challenges by enforcing principles like polluter pays and precautionary measures. However, effective implementation requires stronger regulatory frameworks, enhanced public participation, and capacity building for enforcement agencies. Comparative analysis. The Doon Valley case and sustainable development are interconnected pillars of Indian environmental law. The rural litigation case laid the groundwork for recognizing environmental protection as a constitutional duty, emphasizing the need to preserve ecologically sensitive areas. It prefigured the sustainable development principle by balancing economic activities, mining, with environmental conservation, quarry closures and afforestation. Sustainable development, as articulated in Vellore Citizens Welfare Forum, builds on this foundation by providing a broader framework that integrates economic, environmental, and social dimensions. Both the case and the principle underscore the judiciary's role in enforcing environmental accountability, with the former focusing on immediate ecological protection and the latter offering a long-term vision for balanced development. 98.